Judge, that motion here, they want, to adjourn that case, the several, Wednesday.
Who is that?
Lisa Frederick and,
Why?
Wheeler, prosecutor, Mackenzie Wheeler.
Why do they want to adjourn?
I don't remember what Lisa, she said she wanted to adjourn. And then the hearing for Sean Nelson. That was that tether violator from yesterday.
Oh.
You remember that case? That's the guy who was a rapper or something. So he sent for a comp hearing, but he's out. I think I missed something. It must be traffic of the Montana here. Yesterday she said it was traffic was heavy.
Oh.
Yeah, I do.
Wait. I need an hour to get here.
Didn't really.
This construction.
Where you coming from?
Eberhart,
Oh,
Michigan was all backed up,
No, what?
94. I lived
another court reporter we had that lived in Highland Park. He said the same.
at 7:15. Not gonna be early.
Well, at least you still made it on time.
Yeah, but still, I'd like to get here at 8.
Good morning, Judge. Good morning. How you doing? All right, sir. Certain stages. This is Judge Kenneth. References in contact.
So that's this just section. It was Patricia Holmes.
Oh, okay. So, give me a second, Ms. Holmes.
Yeah, see that.
Okay.
You'll see right here, right here on the screen.
Yes. Okay, great. All right. Okay, thank you so much. I appreciate the return. Thank you, you too.
Tengo más dolido.
Mr. Simon, good morning.
Good morning, Judge.
What can I do for you, sir?
I received some information. Apparently there's no power at the jail. Is that what the holdup is?
I don't know.
Oh.
What are you here for?
Kershawn Nelson, Your Honor.
The Nelson tether violation hearing.
Oh, tether violation.
He was taken into custody on the tether violation, Judge.
Oh, okay. So what do you want to do, Mr. Simon?
Well, Judge, if there's no power, I mean, I can't go see him, and I don't even know if he can be brought over. Maybe we should try to do this again tomorrow.
Okay. He won't be
I
going.
do.
I can tell you that now.
I'm sorry.
He won't be going anywhere. I can tell you that now.
All right. I do have a matter at 9 o'clock. I could be here in person or by Zoom later in the morning, whatever is convenient for Mr. Fedoruk and the court.
I'll be here. The other option you have is you can waive his presence, and we can discuss this now. So you at least know what you're looking at.
Yeah, I read the allegation.
Oh, you did? Okay.
Yeah, I received it from the court yesterday. Thank you very much.
So you're not interested in waiving his presence. You want him, is that right?
Judge, as an aside, he's at the Center for Forensic Psychiatry after 2 referrals.
Okay, you didn't answer my question. Let me try it again. Do you want to waive his presence or not?
No, I prefer not to.
Okay, then we'll see you tomorrow. Oh, wait a minute. Here comes the county jail now.
Oh, okay.
Good morning, Wayne County Jail.
Northeast. Good morning, Judge. How you doing?
Hey, Deputy, do you have a Kershawn Nelson for me?
Kershawn Nelson, he is across the street at Division 2. I will let them know that you want him on.
Are they having any power issues over there that you're aware of?
No, not that I'm aware of. We didn't have him scheduled for you today. I'll let them know that.
Okay, yeah, he's set for probation. I mean, a tether violation.
Morning, can you hear me?
Okay. Okay, I'll let them know.
All right, thank you. Ma'am, that's here to see me. Yes. What can I do for you? Please come up to the podium. Right here.
No, I just want to introduce you to you from Mary Saunders. I just wanted to say hello.
Oh, okay.
Okay. That's nice to meet you.
What's your name again?
It's Patricia Holmes, but she called me by my middle name, Lynn.
Oh, okay.
Yeah.
All right. Very nice to meet you.
Okay. All right. Thank you.
Okay, take care. All right, Ms. Frederick.
Good morning, Your Honor. Mr. Wheeler and I have the need to have our case adjourned. It's scheduled for tomorrow. However, we just received a huge load of digital discovery, including 4 Kids Talk videos, and we need to adjourn. Your clerk indicated that we should show up by Zoom this morning to get that done.
What time is this scheduled for tomorrow?
10:30 a.m.
And you can't view it in 26 hours?
Your Honor, that is not the only matter that I'm having to deal with, and no, I cannot.
When did you receive it?
Yesterday afternoon. It took all morning all afternoon to even download it. I didn't even get it onto a flash drive until the close of business. Or should I say upload it?
Let's call.
Okay. Call me. Case number 2405-746901 before State of Michigan versus Tony Hart. Defendant is charged in counts 1 through 3, criminal sexual conduct, first degree. Count 4, child sexually abuse activity, aggravated. Count 5, criminal sexual conduct, assault with intent to commit sexual penetration.
Appearances for the record, please.
Mackenzie Wheeler for the people, P86308.
And good morning again, Your Honor. Lisa Frederick, P53372, appearing on behalf of Mr. Hart, whose presence I would like to waive.
Wait, defendant's presence, Mr. Pleasure.
Thank you, Your Honor. So counsel and I have two possible dates that we can work with, and that's going to be the 18th or the 26th.
See you later.
State your motion on the record, please.
So, Your Honor, as I'd indicated, we would ask the court for an adjournment on this matter in light of the fact that we have quite a bit of digital discovery to review and just received it yesterday. I think, in fact, Judge, the protective order came through Friday. You didn't get to sign it, I don't think, until late Monday or something like that. I mean, it was just a lot of delays in terms of getting the information to us, and then it was quite a bit to upload, and we haven't even had a chance to look at it.
And why can't we do this Friday, 14th?
I have some medical issues, medical appointments on Friday, Judge, 3 of them.
How many witnesses on this case, Mr. Wood?
There'll be 3, Judge.
June 17th at 11?
No, Your Honor, I'm in Taylor with 2 exams.
I thought you said you were available on the 17th.
No, Judge, I said the 18th or the 26th.
The 18th is my homicide day.
How is the 26th then, Judge?
Too far out. 21st?
In the afternoon?
No.
Ugh.
10 o'clock?
I'm sorry.
10?
Can I be late without you being upset? Because I've got 2 things going on that morning.
What time are your 2 things?
9:30 and 8:30. And one of them is a bond motion. The other is a plea. It's going to a final pretrial. That's going to be a plea. And I obviously don't know what else is going on. Go ahead. And those are in circuit.
That shouldn't take very long, 11 o'clock?
Okay. 11 o'clock, 21st.
Yes.
Thank you,
We
Judge.
continue. Ms. Irwin,
Good morning, Judge.
good morning. What can I do for you?
I have Eberhart and he's locked up and I would like to set this for exam.
Do you want to waive his presence? Ms. Irwin, do you want to waive his presence?
Oh, yes, I will, Judge. I'm sorry.
Okay. No problem. We're ready on Eberhart.
Calling case number 2405-657201, people of state of Michigan versus Beyond Praise, Eberhart. Defendant is charged in count 1, unlawful imprisonment, counts 2, 3, and 4, criminal sexual conduct, first degree. Count 5, assault with a dangerous weapon. Count 6 and 7, weapons, felony firearm. Count 8, assault with intent to do great bodily harm, less than murder or by strangulation. Count 9, domestic violence.
Appearances for the record, please.
Sally Irwin on behalf of Mr. Eberhart. I'm waiving his presence if that's acceptable to the court.
The court will waive the defendant's presence. Do I have an APA here on Eberhart? It doesn't look like it. I'm sorry, Ms. Irwin, we don't have an APA here just yet.
Okay, I'll hold until you get an APA.
Okay, thank you.
Judge King, can I speak with my lawyer for a second?
What's your name, sir?
Kershawn Nelson.
Oh, okay. I'll put you in a breakout room.
Thank you.
Mr. Simon, your client wants to speak to you.
Yes, thank you.
Go ahead and join. Mr. Daniels, what can I do for you? Why you keep raising your hand?
Sorry, Judge, by mistake.
Oh, okay. We're just waiting on your attorney, sir.
Understood.
He's in Wayne County. He's in Wayne County. He is, so he should be. Yeah. I saw the same problem. The system's not updated. Right. But I found one. Okay. Good.
Good morning, Mr. Woodyard.
Hi, Judge. Good morning. How are you, sir?
Good, sir. You're here on Mr. Daniels.
Yes, I am.
Daniels.
All right, case number 2405-737001, people of the state of Michigan versus Anthony Daniels. Defendant is charged in count 1, home invasion, first degree. Defendant also has case number 2405-750601. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, criminal sexual conduct, assault with intent to commit sexual penetration.
Appearances for the record, please.
Anthony Daniels.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And Judge, good morning to you and your staff. Good morning, Michael Woodyard. My P number is 64612. I'm a staff attorney at Neighborhood Defender Center, and we represent Mr. Anthony Daniels. Good morning.
Good morning. Ms. Drain, are you representing the people on both matters?
I believe, Judge.
Okay, what's your pleasure, Mr. Woodyard?
Judge, we're going to need to schedule this for a preliminary examination. And before we close the record, I just want to get from Mr. Daniels his accurate contact information.
Okay, how is June 17th at 11 o'clock?
My screen will go dark for a moment while I check my calendar. You said the 17th?
Yes, sir, at 11.
Judge, I have a preliminary exam scheduled at 9 a.m. in the 34th District Court in Romulus. So I'm afraid that would be cutting it close. Could we do it later that day?
The latest I can go is 12:30.
Sold. I'll take 12:30 on the 17th.
All right, June 17th at 12:30, bond will be continued.
Thank you. And Judge, may I ask Mr. Daniels for his telephone number, please?
Yeah, you want it now or you want it in the breakout room? I'm sorry.
Actually, Judge, would you mind? Could you pop us in a breakout room and we'll just then exit from there if that's okay with the court? Are you able to do that?
Sure, hold on a second.
Thank you. Thank you, Judge. And so we're done with the record then, is that correct?
Yes.
Thank you, sir.
Judge, that's Ms. Drake's her case. That's what Whitney Johnson, this is a DV case. The domestic violence unit with one another.
They have to call this case. So this next coordinated to.
Ms. Strange,
Yes, Judge.
are you the APA on Eberhart?
Yes, I am.
Oh, okay.
Calling case number 2405657201, people of the state of Michigan versus Bill Praise Eberhart. Defendant is charged in count 1, unlawful imprisonment, count 2, 3, and 4, criminal sexual conduct, first degree, count 5, assault with a dangerous weapon, count 6 and 7, weapons, felony firearm, count 8, assault with intent to do great bodily harm, less than murder or by strangulation, count 9, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Ms. Irwin? Ms. Irwin? I think she's froze. No, she's not. Okay, let me have your appearance, Ms. Irwin. Your appearance, Ms. Irwin.
Sally Irwin on behalf of Mr. Eberhart. I'm requesting his personal appearance be made for this morning's setting of a preliminary exam.
All right, the court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination. How is June 17th at 11 o'clock?
17th. No, Judge. I can't do it. I can't do it at all on June 17th. The 18th, I might, yeah.
No, ma'am, that's my homicide day.
Okay.
We're closed Wednesday. Thursday is my homicide day, so it moves us to Friday. How about June 21st at 10 o'clock?
I could do it later that morning, Judge.
June 21st at 12 o'clock?
Yes.
So Okay, June 21st at 12 o'clock, bond will be continued.
Judge, may I request a DSU for that time?
I'll make the referral. Thank you. Have a good day.
Thank you.
Mr. Simon, are you ready now?
Yes, Judge.
Ready on that.
Case number 2206-047001. People of the Spanish versus Kershawn Nelson. Defendant is charged in count 1, operating license suspended, revoked, denied, causing death. Count 2, operating license suspended, revoked, denied, causing serious injury. Count 3, moving violation causing death. Count 4, moving violation causing serious impairment of body function. Defendant has a felony commission with the motor vehicle adult advisory and a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Mark Fedoruk for the people, P76177.
Good morning, Your Honor. Jonathan Solomon, P35596 on behalf of Mr. Nelson.
Mr. Nelson, tell us your name, sir.
Kershaw Nelson.
Okay, so Mr. Nelson is before the court on a tether violation. Allegedly, he put aluminum foil over the tether so that it would pick up where he was at. Mr. Simon?
I'm sorry, the court asked me for a response?
Yes, sir.
Your Honor, I've had an opportunity to discuss the allegations with Mr. Nelson. We believe that they are speculative at best. He indicates to me that there was no tampering. I think it's equally or perhaps more likely that there's a defective tether. This was something which was first arose when Mr. Nelson actually came to the tether office. There's been no other indication other than this rank speculation by the tether department that there's been any tampering. And we asked the court to find that there's been no violation or to set the matter or insufficient evidence of a violation and or to set the matter over for an evidentiary hearing.
We'll set an evidentiary hearing if that's what you want.
And
we have an exam scheduled in this matter?
Your Honor, it's
Judge, I think
pending
it's
a
probably not
competency
until August.
evaluation.
Yes, he's twice been referred to CFP and he still hasn't had an interview.
So this should make the matter go a little more smoothly since he's in custody.
Well, I accept that if he's not in violation of the tether, he should not be in custody.
Well, that remains to be seen, doesn't it?
Yes,
That's
Judge.
what we're talking about an evidentiary hearing.
Exactly.
Can
Would you like to do the hearing, sir?
Well, Judge, I don't know about Mr. Fedoruk, but I would be available after sometime later tomorrow morning or
Maybe too soon.
or we can also do it on the on Friday, the 14th.
I don't know. Is that enough time for you, Mr. Fedoruk? I was thinking about at least a week from today.
Yeah, so I would guess you want to hear from someone from the sheriff's office who monitors the tether.
Yes.
Okay. So if we can have just at least a week to subpoena that person.
Can I speak, please?
June 26th.
Can I speak? Can I speak, Your Honor?
Wait, I'm sorry. Did you say June 26th?
Yes, sir.
Yeah, I have the morning available, although I'm concerned that Mr. Nelson will then have been in jail for 2 weeks for something which is a mere allegation.
Oh, that's right. I didn't want to go 2 weeks out. How about June? We can do it a week from today, June 18th at 8:30.
Yeah, can we go the 19th? Is that possible?
No, we're closed, and you're closed on Juneteenth.
Oh, okay. Yeah, that's fine. 18th is fine.
Can I speak, Your Honor, please?
And that's at what time, Your Honor?
8:30.
Okay, thank you.
I'm sorry, what date was that at 8:30?
June 18th.
June 18th. No, I'm sorry. I'm scheduled for preliminary examinations in Macomb County that morning. And I have pre-trials that afternoon. I could do it the 20th.
I can do it the 20th at 8:30.
Yeah, the 20th or the 21st, whichever is better for the court.
We'll do the 20th.
And I do have a matter in circuit court at 9, so as long as we start, I guess, promptly.
First come, first serve. You guys get here, we'll take care of it.
Okay, then that's 8:30 on the 20th. Or well, Your Honor.
Yes.
Okay, very good. And if perhaps somebody could check with Center for Forensic Psychiatry to find out, what the status is on that last referral.
All right.
Can I speak, please, Judge?
Defendant's going to be remanded. Mr. Simon, your client is dying to speak to me. Mr. Simon?
Yes.
Your client is dying to speak to me.
Okay, well, that's fine. We can have a breakout, and then since we've finished our business and set the new date.
No, sir, he wants to speak to me.
Oh, he wants to speak to you. No, I don't recommend that.
Yeah, but can I please speak to the judge, please?
Well, I mean, I don't think he'll say anything incriminatory, but I can't be sure of that. And I would probably like to break out with him first to find out what.
Yeah, but it ain't nothing I can say to incriminate myself, sir. I just want to speak to the judge. It ain't really nothing I can say to incriminate myself.
Well, I don't recommend it, but because I don't know what you're going to say.
I speak to the judge, please.
Your call, Mr. Simon.
No, Judge, I don't think so.
Okay. All right. Bond will be set at remand for now. Thank you.
Thank you. Mr. Nelson, I'll be at the jail to see you later this week.
You don't even pick up the phone. I'm trying to talk to my judge. God. There ain't no hot water in this motherfucker. No electricity. Bro. CO. CO.
Excuse me, Judge.
Yes, sir.
Is your 11:30 going?
11:30?
Correct.
As far as I know, very different.
No, they didn't bring them, so I gotta order them out. Just check on you first.
Oh, yeah. As far as I know, it's supposed to be.
Okay.
What's the day's date?
know, Judge, I just found out maybe 3 weeks ago that I knew Gary Jones' wife. I didn't even know.
Oh, really?
I remember them when they were kids growing up.
Mm-hmm.
Her name is Daria or something like that. Yeah. And I never put the two together. I know all her sisters. And it was interesting because none of them was down here for the exam. You know, I found out, I ran into one of her sisters. And she did watch it. One of her sisters watched it on Zoom. They saw me, and that's why they contacted me. Yeah. And I was like, man. And it's funny, I never met her kids before because I hadn't seen them. I've seen two of their sisters in recent years, but not her.
I hadn't seen when she's in babies.
Right.
Jefferson. This past
Yeah.
So I didn't see the two years.
Wow. She didn't.
I didn't see it.
Wow. Yeah, it is. I didn't. I understand that he's doing good. The son doing good. It's like close to a genius. Just like. But that was something. And then one of the sisters, I'm just surprised he didn't reach out to me and tell me and say nothing.
See if you can make out what this lady was saying.
So, is your cousin been arrested? What's his name? SAMED. What's the last name? Samed Mia, MIAH. Responded. They have to see your baby. Baby, so, go to the hospital. Take the baby to the emergency. Help take the baby to the emergency.
He'll take care. Certainly, Mr. Stewart. Get that as a turn. Yeah. Very comfortable. Okay. They said they were get Stewart.
As far as your.
DOC last night.
They want to spend the time.
No, it's Coleman. Trying to talk to them.
Also contact social services. Social services.
how you doing? I'm trying to get a ETA adjustments to come to the adjustment.
Okay, try calling this number.
36.
313 833
Yeah.
7730. 7730. It's 313 833 7730. Sorry? Contact social services for the church. All right. Right here.
I think I haven't seen Mr. Keto yet. The witnesses are here.
Okay.
And officer in charge.
Yeah. I appreciate it. There you go. Do it. Shut up. Sorry. Yeah. All right.
or if you have to do a formal Theodore.
That's what I got.
Yeah, it's Theodore. There's two of those names in the partner.
Which one do you want?
I'm the one without a 3P number. My father was an attorney. He's a judge here actually. But, yeah, so.
So we're going.
Yeah. He's dead, so I'll do it. And personally, I'll betray because I'm the third, but that prosecutor's.
Yes.
Sure.
You know this for sure. James Keegan. Yeah, K-E-H-O-B.
Which first week?
James.
Did you reach that number?
For the AP?
Yes, ma'am.
Procedural.
Definitely. Just this one.
That's just. Let's see.
Yes.
Well, I typically only send it one time,
Yeah.
so I'll look at the audit log, like, I know what I sent, so it's just like, that's the good. That's it. Yeah. Yes.
Are we ready, gentlemen?
Yes, sir.
Okay.
Getting on the Zoom, Judge, so it's gonna take me a moment.
All right.
Have a seat next to your attorney, stand up when the judge call your name.
Let me know when you guys are ready.
I'm just getting on now, Judge, so I should be okay.
Okay.
The court's ready.
All right. Calling case 2457404, people of the state of Michigan versus Benny Carter Jr. Defendant is charged with count 1 homicide, murder, first degree premeditated. Count 2 felony firearm, third offense notice. Defendant has a habitual offender, fourth offense notice. Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe. My P number is 82812 of the applicant.
Good morning, Your Honor. Good morning to your staff. My name is Ted Wallace, P80922, and I represent Mr. Carter, who stands to my left. Mr. Carter, please state your name.
Today is the date and time set for preliminary examination. Are we ready to proceed?
We are, Your Honor.
How many witnesses?
Between 1 and 4, Judge, depending on the nature of the proofs, but optimistic.
Do you have any preliminary matters before you call witnesses?
Yes, Your Honor. First, there's going to be a stipulation to the identity of the deceased, Cedrico Granger, for preliminary exam purposes only, Judge.
So stipulated, the court receives that stipulation.
Second, Your Honor, there's going to be a stipulation as to Mr. Carter being previously convicted of a specified felony, which will be for the amended, second amended court act, which will be the felony possession count, just for today's purposes only, Judge.
Where is that at?
I have it, Judge. Would you like it now?
Yes.
Okay. Show Mr. Wallace first, Judge. Publish the court, Judge.
You may.
Judge, for the record, that would be for the amended count 2.
All right, so the charges are homicide, murder, first degree premeditated, count 2 weapons, firearms, possession by felon. I thought they renamed that statute.
It should say prohibited person, does it not say on there,
It
Judge?
does not. It says possession by felon. Count 3 weapons, felony firearm, third offense notice. Defendant, count 4 felony firearm, third offense notice.
I will,
It has an official offender, fourth offense notice.
yes, sir, I would make that those changes, and I'll have a new file for the count 2.
Okay. All right, that being said, you may be seated.
Thank you. For clear, Mr. Wallace, that stipulation for today's purposes only.
Yes.
And then lastly, I move for the admission of what's going to be marked as first proposed exhibit number 1, which is the medical examiner's report in this case.
Okay.
All right, and this,
For today's hearing.
May I publish to the court, Your Honor?
yes.
All right, this is coming from ME case number 24-06216. This is performed by Dr. Catherine Perez, P-E-R-E-Z, Assistant Medical Examiner on Cedrico Eugene Eval Granger back on May 14th, 2024. It's my opinion that death was caused by gunshot wound to chest. Postmortem examination demonstrated a penetrating entrance gunshot wound, GSW, on the right chest. There was no soot or gunpowder stippling noted on the skin surrounding the wound. The wound track proceeded from this injury through the right 6th anterior rib, diaphragm, liver, left adrenal gland, left kidney, mesentery, left posterior 11th rib, and ended in the left back. associated with this injury was 500 milliliters of hemothorax. The wound track was from front to back, right to left, and downward when the body is viewed in the standard anatomical position. A deformed jacketed bullet was recovered from the left back and retained. The manner of death is homicide, and that was signed by Dr. Perez on May 29th of this year, 2024.
All right.
Lastly, Your Honor, at this time, I'll be moving for the admission of proposed exhibits 2 and 3 pursuant to stipulation, Your Honor.
Court receives that stipulation. Yes. Exhibits 2 and 3.
Thank you, and may I just publish on the screen, Judge?
Yes. There you go.
Thank you, Your Honor. So for the record, Your Honor, just so it's clear in the transcript, Exhibit 2 is going to be coming from camera channel number 7. I'm going to be beginning that video at the 6-minute and 16-second mark, Judge.
Is it? There.
Doing it from the browser, so I'm a little bit slower on this end. And beginning from the 6:16 mark, Judge. One moment, may I just have a second, Judge? I apologize. I apologize, Your Honor. And I guess I should have asked Judge before I go any further for a mutual order sequestration, with the exception of Detective Fielder, who is the officer in charge.
Any objection? Okay.
For the record, I stopped Exhibit 2 at the 6-minute 30-second mark, and I will be resuming from that point. Stopping exhibit number 2 at 6 minutes 45 seconds, Your Honor. Now going to what is People's Exhibit number 3. For the record, Your Honor, this is going to be from camera number 15, People's Exhibit 3. Just want to jump to where we're starting action. Sorry about that, Your Honor. I have tech issues, but coming back on Exhibit 3. For the record, we'll be starting exhibit number 3, channel 15 at the 11-minute 9-second mark. Your Honor, I stopped the video at the 12-minute 40-second mark. I have for exhibit 30, Judge. So at this time, Your Honor, I believe I have no further preliminary matters at this time. At this time, I call Delano Lewis to the stand. Lewis.
Yes. Okay. Sir, please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat in the witness box next to me, all the way up here. Voice up nice and loud and speak to that microphone that's to your left. When you're ready.
Thank you, Your Honor. Good morning, Mr. Lewis. Could you just state your name for the record, please, sir? Delano Lewis. Thanks, sir. I want to draw your attention back to Mother's Day of this year, May 12, 2024. Okay, sir? Yes, sir. Okay. Where were you that morning, sir? And where's work at?
11-4-1-4,
And very silly question, Mr. Lewis, but is that in the city of Detroit?
Yes, sir.
Did something out of the ordinary happen at work that day that brings you to court, sir?
Yeah.
What happened, sir?
Saw two people get into an altercation at the store. And seeing things were pretty ugly, so I went to the back of the store.
Okay, well, talk about the altercation. What happened?
I really couldn't say, but at that point, I went to the back of the store.
So, Mr. Lewis, you spoke to the police at length about what you saw that day. Is that fair?
Yes.
Okay, remember giving a statement about what you saw that day?
Yes.
Okay, so what happened when those two people get in that altercation?
I don't know what was said.
That's okay.
Either they finished saying what they were saying, or I heard it was very shut.
Okay, did you see who the individual was with the gun?
No, I didn't, but I looked at the camera and seen who it was.
Well, who was the shooter with?
Objection.
Well, he came to the store, he was with some girl.
Objection. He's not. He didn't see who it was. Identified by the camera.
Did you see someone come in the store with the girl, sir?
Had you seen this individual before?
Yeah, regular that comes to the store often.
Okay. And so after this individual and the girl he comes into the store with walk in, what do they do?
He went to the ATM, I guess to draw some money out or whatever. Came up to the front, purchase what they purchased. Not aware what they had purchased.
That's okay. So they come up to the front, and what's the next thing you see after the purchase?
I see young man come in the store and he said something to him.
Who said something to him?
The guy that was at the counter purchasing things.
Okay. Do you recall what he said to the young man?
No, I do not.
Okay. Do you recall what that? Hold on. So do you recall what that individual at the counter was saying? Or not saying, excuse me, what he was wearing?
He moving or whatever.
What about the guy that walked in?
I don't know, man. I was kind of shook up, man. I heard that gunshot, man. Couldn't bring a focus.
That's okay. So you see the man and the girlfriend at the counter, and the new younger man walks in. Is that fair?
Yeah.
Okay. What happens after the young man walks in?
What do you say? Like I said, I ran to the back to get a few things from the store. I heard them arguing about it.
Okay. What about the gun? When did you first see the gun?
I didn't see nothing. I just heard a gunshot.
Hold on, so your testimony today is that you never saw a gun?
No, I haven't.
Okay, but you told the police that you saw a gun. Do you recall that?
No, I said, I didn't see nothing.
So if I showed you your statement where you said you saw the gun, you wouldn't recognize it?
Yes, sir.
Okay, well, I'm gonna show Mr. Wallace page 1 of your statement. Connor, may I approach?
Right.
Mr. Lewis, I'm gonna ask you to read this paragraph to yourself. Don't read it out loud, okay? So first, Mr. Lewis, this is your statement that you signed, is that correct? Okay, you told the police that you actually saw the gun, isn't that true?
No. See no gun.
Okay, well, let's try it this way. After you gave the police a statement, you were shown a series of photographs, weren't you?
Yeah.
Okay.
I believe, man,
Hold on, Mr. Lewis, let me ask the questions, okay? Would you recognize that photograph if I showed you?
Yes, you are. I guarantee you are.
Mr. Lewis, I showed you that photo, you'd recognize it, wouldn't you?
Yeah.
Okay, I'm gonna show Mr. Wallace proposed exhibit number 4. May I approach it?
Man.
What did I hand you, Mr. Lewis?
Photo.
Okay, you is that the same photo that you observed when you were with the police that day, sir?
Yes, sir.
That's your signature in the bottom corner there, sir?
Yes, sir.
Other than the exhibit sticker I placed on there moments ago, have there been any changes or alterations, sir?
See, you can tell the question.
Has that been changed in any way other than the exhibit sticker, sir? All right, I move for admission of proposed 4.
Okay. Admitted.
And published. Well, actually, so can you flip that over, Mr. Lewis? Can you read to the court what you stated on that form, sir? Or that photo, I should say. Yes.
What's the problem, sir?
Yeah, I don't really.
Why?
I don't. I didn't want to get involved in the situation from the beginning.
Okay, but you are now. You can't plead the fifth, sir. Okay, then the court's gonna hold you in contempt of court. He can exit stage right. I'll get him an attorney. You have another witness? I don't have time for your game, sir.
I published this to the court.
Yes.
One moment here.
Put your hands up on it.
Are you right? This I'm gonna call Trevina Goodman to the scene. Trevina. Goodman, Goodman. CR234 is in Victor.
Ma'am, please step forward. Raise your right hand. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Please have a seat. The witness box right next to me. Voice of nice and loud, speak to that microphone. It's to your left.
Good morning, Ms. Goodman. Could you just say your name for record?
Trevina Goodman.
Ms. Goodman, I want to draw your attention back to Mother's Day this year, which was May 12th, 2024. Where were you that night?
Work.
Where's
I'm liquor store.
Okay, where is the liquor store at, ma'am?
On Illinois.
Okay, is that in the city of Detroit, ma'am?
Yes.
Okay. Did something happen that was unusual that brings you into court today, Ms. Goodman?
Yeah, my customer shot me.
Okay. How did that start? How did the incident begin?
30 minutes into my shift, I was ringing on a gentleman. He was getting 3 beers and 5 black and mild. As I was cashing them out, another man walked in.
Okay, so I'm gonna stop you there. We're gonna break it up, okay? So the individual you're ringing up, do you recall what he was wearing?
Black pants, black and white jacket.
Okay. Was he with anyone at that time?
A female wearing hot pink, walking with a hood on.
Now you indicated that another man comes in. Do you recall what?
White t-shirt on.
And what happens after that young man walks in?
So the young man walked in, he took about 20 steps to the store, and the guy I was bringing out asked him if he knew somebody in this area. The young man said, huh? He was on the Bluetooth or on the phone or something. So he stopped talking and he said, huh? And the guy said, you know somebody in this area? And the guy was like, hell no. This is my language, is what he said. He said, hell no, F you. And the dude pulled the gun out. I said, no, it's Mother's Day. He shot.
Had you well, after the gunshot goes off, what happens next?
They started he started holding him. The guy was really little, like holding him, you know what I mean? And they kind of got a squabble, a fight. And then the young man collapsed by the front door, and the guy started scuffing him and choking him. And then he walked out the store, and then he came back and told the girl, bring your ass on.
So before the shooting, had you seen any other firearms that morning?
No.
Okay. Did you ever see the young man that walked in with the firearm?
No, he was on the phone. He was like happy, like, you know, he walking somewhere and he jumped up, I don't know, I mean, I think he was in good spirits. So,
you're kind of like bouncing.
Yeah, I guess he was walking into the store, whoever he was talking to, he was happy.
All right, that's okay. Had you ever seen any of these individuals in the store?
I had just started working there. It was my first week.
All right. Could you just describe to the court what kind of gun did you see?
A chrome, like silver.
Okay. Apart from the interaction between the shooter and that young man, did you hear the shooter say anything else that day?
Keep your eyes on the prize and off my beach.
When was that said?
Before he shot. Before he was me.
Thank you, Ms. Goodman. Your Honor, I have no further questions.
Cross examine.
Thank you, Your Honor. Good morning, Ms. Goodman.
Good morning.
Just gonna ask you a couple questions. The first thing you said is the individual that walked in that was on the phone, you said that he was wearing a white t-shirt?
Yes.
Okay. And then the person that you were helping at the counter, you said he pulled out the gun and, out of his holster?
Yeah.
Okay. And then he just shot him?
Yeah.
Isn't it true that, they actually started fighting over the gun before the?
No.
Okay. And so if the police wrote that in the report, that would be a mistake, correct?
I didn't see it.
You didn't see that?
Nope.
Okay. And then you said that this person in the white t-shirt started stomping and choking or no. The person, the customer who just pulled the gun out and shot, just started stomping and choking.
Sure did.
Okay. The guy that was wearing the white shirt.
Sure did. Every spoke to say yes.
Okay. And then you weren't able to identify the person in the photo lineup either, were you?
I have no idea.
Okay. All right, I don't have any more questions.
Any redirect?
No, Your Honor.
All right, thank you, ma'am. You may step.
Very slow. Your Honor, I believe like to be recalled. The court is okay with that.
Okay.
No cups or no cups?
We'll take them. Before you begin, Mr. President, I want to address Mr. Lewis. Mr. Lewis, I don't like to have my time wasted, and I promise I won't waste your time. This is a very serious case here. We have a person that lost their life. We have another person who sits here charged with the harshest penalty that we offer here in the state of Michigan. I don't have time for your game, sir. You understand me? All right, you may proceed.
So Mr. Lewis, I'm gonna go back to where we left off, okay, sir? Prior to you hearing the gun go off, what did you first notice about the situation?
The young guy that got shot.
Which one was the young guy? I want to make sure we're on the same page.
He worked at the car wash behind the store.
Okay. When the young guy came into the store, was he alone or was
He was alone.
Okay. Who was the one that shot the other guy?
Yeah, that was at the counter,
Where were you standing when you observed all this, sir?
behind the counter.
And I know it's a long counter, is that fair?
Yes, sir.
Okay. Which end of the counter were you closest to, the back door or the front?
The front entrance.
Prior to the gun going off, did you see any other guns before that?
No, sir.
Okay. Did you see where the gun came from?
Yes, sir.
Where was that, sir?
Yeah, it was standing at the counter.
Did you see what kind of, what color it was?
See, by the time he pulled it out, I already knew what was happening next, so I ran to that.
Okay, do you recall what kind of gun it was? And did you hear anything other than the gunshot, or anything said other than the gunshots? Or?
No, sir.
Are you sure about that? Are you sure about that, Mr. Lewis?
Yes, sir.
Okay, so. And again, I showed you the statement earlier this morning, Mr. Lewis. I showed you the statement earlier this morning, Mr. Lewis. Your statement?
Yeah.
Okay. You recall telling the police that you actually heard, do you know anybody around here? Do you recall saying that?
Yes, he did say that to the guy.
Who's the he that said that?
The guy that was at the counter.
Okay. Was there any sort of response to that question?
Yeah, the guy that walked in the store said, what are you talking about? And he left alone and kept walking. And the guy at the counter asked him again. At that point, the guy walked up on me.
And then, so after he says it again, and you said he walked up on him, did I get that correctly?
Yes, sir.
Who's the he?
The guy that got shot.
Okay. So the guy that gets shot, the younger, we'll call him the young guy?
Yeah.
Did you know who the young guy was?
Not really, I just wanted to come in the store.
Okay.
Like I say, work at the car wash behind the store.
Okay. The young guy comes up. About how long after do you hear the gunshot?
Right after the little guy walked up, my little homie walked up.
Okay. How many gunshots did you hear?
I just heard one.
After the gunshot goes off, what happens then?
I ran to the back.
Okay. How long were you back there?
Right back there about maybe 5 minutes.
Okay. When you, after you go back and come out 5 minutes later, was anyone still there that was part of this situation?
All he wanted was there was the homie that got shot.
Did you see the shooter at any point later that day?
No, sir.
And what about the individual he came?
No, sir.
Thank you, Mr. Lewis. Judge, I have no further questions.
Mr. Lewis. So you said that you really can't say what happened. Is that the truth, or is what you just said the truth?
I don't understand that question.
Okay. I apologize. I was kind of. Earlier, you said that you couldn't really say what happened. You remember saying that?
No.
Okay. And then you said you never saw a gun. Isn't it true that the younger guy that got shot You said he walked up on the guy that was behind him, that was paying for his stuff?
Yes, sir.
He came up at him aggressively, correct?
Yes, sir.
And then the guy that was at the counter pulled the gun out, correct?
Yes, sir. And I ran to the back, so I didn't see the customer.
Okay, but did you see the young guy that got shot go after the gun?
Yes, sir.
So the younger guy came up to the smaller guy. He just came up to him aggressively, correct?
Yes.
And the younger guy pulled the gun out, correct?
Yes.
And the younger guy that got shot went and tried to grab the gun, didn't it?
Yes.
And that's when the gun went off, is it?
Yes.
Okay. Thank you. I don't have a question.
I have no further questions, Judge. Sir, Mr. Kehoe said that he was gonna pick up where he left off, but he didn't exactly do that. You picked someone out of the lineup, is that right?
Yes, sir.
And he handed you People's Exhibit 4. I want you to take a look at that. The lineup that you looked at, was it a photo lineup?
Yes, sir.
And how many photos did you look at?
Two.
Just two? They just gave you two photos?
They gave me multiple photos.
Okay. That photo that's in your hand, People's Exhibit 4, did you pick that photo?
Yes, sir.
Why did you pick that photo?
That was the shooter.
All right. So that was the person that you saw pull the gun, but you didn't see the actual shooter. Is that what you're telling me?
Right.
All right. And you signed that as the person that you picked, is that right?
Yes, sir.
And I believe Mr. Kehoe asked you to turn the photo over, and there's something that's on the back of it. What's on the back of it? Okay, what, is it at the bottom?
Yeah.
Okay, what does that say?
This is shot suspect.
The shot. What does it say?
This is the guy that pulled out the other one, shot suspect. He shot.
It's shot. It doesn't say suspect, does it?
Yeah.
Let me see it. This is the guy that pulled the gun out and shot suspect. And that person that you identified in that photograph, you see that person in the courtroom today? Okay, can you point to him and tell us what he's wearing? Record should reflect that the defendant has pointed to and identified the defendant, Benny Carter Jr. Any questions based on my question?
No, Judge.
Thank you, sir. You may step down. Any other witnesses for the people?
Your Honor, we'll call, I believe, last Brenda Allison. Pretty sure I got it right. TALIS. Go ahead.
Good morning, ma'am. Please step forward and raise your right hand. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. Please have a seat in the witness box right next to me. Keep your voice up nice and loud and speak into that microphone and be to your left once you're seated. Okay, when you're ready.
Thank you. Good morning, ma'am. Could you state your name for the record, please?
Brenda Allison.
I want to draw your attention back to Mother's Day of this year, Ms. Allison, which I believe was May 12th, 2024. Where were you that day?
Well, I was at home and I went to the store I work at. It was my day off. I went up there to use the ATM.
Which store is that?
Dicker Legend, 1 1414 there it was.
About what time did you get over to Liquor Legend?
A little after 4.
And when you get to Liquor Legend, did anything happen that brings you into court today, ma'am?
Yes, I went, like I said, to use ATM. Since I worked there, I went to the behind the counter, spoke to my coworkers through the first door. I went to the length of the store, came out the second door, near where the ATM is at. I went to the ATM to do a transaction and it declined. So I took my card out and we have this office. So I was like behind it. I was still outside, but on the office side. I went to use my phone to call the card because to see what was wrong. Before I could even pull my phone out, I heard a gunshot.
Where did you hear? So where did you hear the gunshot come from?
The front of the store.
Okay. When? How many gunshots did you hear?
Pardon me?
How many gunshots did you hear?
1.
When you hear that gunshot, what do you do next?
I'm already back here, so I kind of ducked to, I see my coworkers running towards me, but once again, I'm on the outside of so they're still, running. So I ducked down and then I asked the young lady who was in the pink, I don't know her name. I said, what happened?
And without telling me what she said, what's the next thing that occurs?
The next thing that occurs, I peek around the corner and I see a guy struggling to get his arm from underneath the guy's body that's on the floor.
Okay, so I want to start with the person on the floor. Do you recall what they're wearing?
I know he had on the blue shirt because he worked at the car wash and some jeans.
And what about the other individual?
Pardon me?
What about the other individual?
What did he have on?
Yes, ma'am.
I'm not sure what he had on because at this time I go, after I see that, my coworkers let me in the door so I could be safe. Once I get in the door, I pick up the store phone and call 911.
And you indicated that the man was trying to get his hand out, is that what you said?
From underneath, yes.
Could you see what they were struggling over at that time?
No, he was trying to pull his hand from underneath the gentleman's body that was on the floor.
Okay. At any point, did you see a firearm that day?
Did I see it? No.
Okay. Apart from. At some point, Ms. Tallison, did you speak to the police about what you saw occurring on that day, ma'am?
Yes.
Okay. After that discussion with the police, were you shown anything by the police?
Was I what?
Were you shown anything?
Yes, photos.
Okay. If I showed you one of those photos today, would you be able to recognize it?
Yes.
And why were you shown the photos, I guess I should ask?
I was shown photos to see who was that could identify who was in the store at the time.
Okay.
Of the shooting.
Do you recall about how many photos you were shown that day, ma'am?
Total, maybe, I don't know, it was 7 or 8 male, 7 or 8 female.
Okay. I apologize, I didn't make a copy, sometimes you just have a moment to make a copy of it. I'll be showing Mr. Wallace what I'm marking now as people's proposed exhibits 5 and 6. May I approach, Your Honor?
You may.
I'm going to show you these two sheets. Now, you can hold on, please, if you'd like. So starting with what is marked as people's proposed exhibit number 5, what is that?
It's a picture of the defendant.
Okay, is that the same photo other than it was a color copy that you saw back in May of this year, ma'am?
Yes,
Have there been any changes or alterations apart from the exhibit sticker, which is in the top right corner there?
no,
Okay, and then turning to number 6, that's okay, Ms. Allison. What is that, ma'am?
eyewitness identification form.
Is that the same form that you signed back in May of this year, Ms. Allison?
Yes, sir.
Okay, have there been any changes or alterations to that form apart from the exhibit sticker?
No, sir.
All right, I move for the admission of proposed exhibits 5 and 6. Is that-
Any objection? They did it?
Thank you. May I publish, Your Honor?
Yes.
Thank you, Ms. Allison. Your Honor, I have no further questions.
Cross-examine.
Thank you, Your Honor. Good morning, Ms. Allison. Good morning. So Mr. Keto just showed you a picture, and it said that you were 100% sure that that was the shooter, correct?
Correct.
But you just testified that you didn't see the shooter, correct?
I didn't say that. I said I couldn't tell you what he was wearing.
Okay, so you did see the shooter.
Correct.
Okay, and so when you said that, all right, so you didn't see the gun? Right?
No, because the shot was already fired.
Okay, and so when you said that you were at the ATM machine and you heard the shot fired, and you looked back and saw and all you saw was someone pulling their hand from underneath the guy on the ground, right?
Yes, I saw him putting his hand under it. There was no one else in the store. When I approached the store, the defendant and his girlfriend was
Okay,
walking
but
into the store.
I'm not asking you that question. What I'm asking you is, you said you're at the back of the store, correct?
Correct.
And when you were giving money and then you were trying to call the card?
Correct.
And you heard a gunshot?
Correct, before I could make the call.
Okay, and when you heard the gunshot, you looked back and you saw someone pulling their hand from underneath the guy on the ground, correct?
Correct.
Okay, so you didn't see the shooting, you heard the shooting.
I heard the shooting.
Okay, so when you say 100% the shooter, there's no way for you to say that, is it?
Why not? He was the only other person there.
Okay, but you didn't see the shooting, correct?
I didn't see the shooting. I heard
Okay,
it.
that was my question. You didn't see the shooting.
Correct.
Okay, so you don't even know what happened up to the shooting, do you?
No, I was in the back.
Okay, so all you saw was someone pulling their hand from underneath the guy on the ground.
The defendant.
Sorry?
The defendant.
You saw someone pulling the hand from underneath the defendant?
Yes.
Okay.
No, the defendant was pulling the hand from the guy who was on the floor.
Okay, so, but you didn't see anything that led up to that, right?
No.
Okay, thank you.
Any redirect?
I'm here.
Okay, ma'am, so how many opportunities did you have to see the defendant prior to the shooting?
Prior to the shooting?
Yes. You said you were walking in the store.
No, I was driving.
When you were driving.
Okay, I was driving.
When you get to the store and you enter the store, is the defendant already there?
They were, as I'm coming into the parking lot, they were coming across the parking lot.
All right, so you had an opportunity to see him then?
Correct, sir.
Had you ever seen him before?
Yes.
How many times?
I mean, several over the year and a half.
You knew who this person was?
Yeah, I don't know personally, but he comes regularly in the store, yes, sir.
All right, do you see him in the courtroom today?
Yes.
Can you point to him and tell us where he's sitting, what he's wearing?
You see it right here, he's wearing the jail.
All right, the record should reflect the witness has identified the defendant, Benny Carter Jr. All right, so you come in, this is your off day.
This is Mother's Day.
Yeah. You go to the back of the store. Did you hear anything prior to the shooting?
I didn't hear any conversations,
Okay.
any loud talking.
You hear a shot and then you see your coworkers running in your direction, is that right?
Correct.
And you say you peek around the corner and
Yes.
that's when you see, you say you see the defendant on
Yes.
top of the person?
No, he's standing. That's not.
Sure.
He's standing up. The victim, his body is on the ground.
Okay.
He's struggling to get his hand, and now I know the gun from underneath his body.
I would object to that, Your Honor. She says now she knows. That's not what she observed then. I mean, how does she know?
Did you see a gun at that time?
No, I just seen him struggling to remove his hand from underneath his body.
All right. Did you see a gun at any point?
No, I never saw it.
But after this is over with, you see the person that was shot laying on the ground, is that right?
Yes, sir.
They appear to be shot.
Yes, yeah, it does appear, you can see the blood. You know what I'm saying?
Did you make any other observations?
No.
Any questions based on my questions?
No, Judge.
Thank you, ma'am. You may step down.
Thank you.
Any other witnesses for the people? Okay. Any witnesses for the defendant?
No, Your Honor.
People? All right, sir.
Share my screen, I apologize, Judge. I'm gonna move to bind over in the second amended complaint as charged, which was just so the record's absolutely clear. The one that charges Mr. Carter with count 1 homicide murder first degree, count 2 weapons, firearms possession by, I should say, prohibited person. It says, I believe, felon. That will be a correction I make in the 2 counts of felony firearms. You heard from Trevina Goodman that this incident started when the young man, the man in the blue and white shirts, talking on his phone, walks in, and the defendant says to him, "Do you know anyone around here?" or something to that effect. The victim says, "Huh?" And then there's something said, and I didn't quite write it down, so I'm not going to try to quote it directly, Judge, about the suspect or the victim had looked at the defendant's girlfriend and then was told to keep his motherfucking eyes on the prize. At that point, you'll see in the video, Judge, that the firearm is flashed, pointing to the ground, and then pointed. For the record, this is Exhibit 2. So first, the gun pointed at the victim, Mr. Green. He then slaps the gun away like anybody would that has a gun that's pointed directly at him. And Judge, you can see for yourself, they're standing 3-4 feet apart at most from each other. Mr. Granger reaches to get the gun away from him, and then it happens very quick, Judge, but you'll see the muzzle flash as the gunshot goes directly into his right chest, as you heard from the post-mortem examination report. And you can see on the video that it's pointed directly within the right chest area. So not only based on the testimony, Judge, but the state or the video itself, this court can find and should find that although there's not a lot of time here, Judge, I'm not going to say that this incident takes very long, but in terms of premeditation deliberation, the length of that time is really a question of facts for the jury. Mr. Carter incites this whole incident asking, "Who do you know? Why are you looking at my girl?" or something to that effect. I don't remember exactly the testimony. And then get the fuck on. And starts first flashing the gun, unholstering the gun, pointing the gun at the floor, and then pointing it at Mr. Granger. All of these to show, to at least intimidate, if not show the progression of Mr. Carter's mental state as he's gearing up to fire that shot. At every stage, he has the opportunity to, hey, I'm just gonna flash the gun. Hey, I'm just gonna point at the floor. Hey, I'm just gonna point at Mr. Granger. But at that point, Judge, Mr. Granger has every opportunity to get that gun away from him. It's pointed directly in front of the judge. And the fact that Mr. Granger slaps that gun away in no way should negate the fact that Mr. Carter has the opportunity to premeditate and deliberate what he's about to do next, which is then shoot Mr. Granger. And then the court sees the tussling that occurs after, but that has nothing to do with the facts that this was all thought out beforehand. And Mr. Granger, as the court can see with its own eyes, at that moment is thinking about one thing, and it's self-preservation, not getting shot again. Your Honor, I ask that you bind over as charged in the second amended complaint and warrant, and I reserve any further argument. Thank you, Judge. Sorry.
Your Honor, everything that was testified, a lot of what was testified to is inconsistent with what the video shows. Goodman said that someone was wearing a white shirt, nobody's wearing a white shirt. She said that my client pulled the gun out and just shot. Everybody else had testified to the fact that all my client did was pull the gun out, and Mr. Granger went after the gun.
That's not exactly accurate. I mean,
well, I'm talking about the shooting aspect of it. There's testimony that Mr. Carter spoke to Mr. Granger, and Mr. Granger came up to him. He was coming at him aggressively. And
is that what you saw in the video?
That's what I saw in the video.
That's not what I saw in the video. Go ahead.
But that was what was testified to as well, is that he came towards my client aggressively. I asked her twice.
I'm a little confused. Do you want me to go by what I saw in the video or what the witnesses said? Because even you had some issues with some of the things that the witnesses said compared to the video.
Your Honor, I want to go. I want you to use your common sense.
I plan on it.
Okay. And as Mr. Kehoe said, Mr. Carter had the opportunity to say, hey, I'm just pointing the gun. And that's all he did. And when he pointed the gun, that's when Mr. Granger came after him. And that's when the gun went off. There hasn't been any evidence that there hasn't been any testimony that Mr. Carter actually was the one that pulled the trigger. What's been shown is that
two men in the story that are in this altercation, so to speak. And one of them is not here to tell us about it. And the other person is the defendant.
I understand. Okay. So, but the fact of the matter is that Mr. Carter the gun didn't go off until Mr. Granger had come after him with the gun in his hand. That right there shows that there was no premeditation. He hadn't shot the gun. And had he intended on killing him after he shot him and they were tussling, he never shot him again. He just he did what he could do to get away from him, and he left. There was no intent to murder anybody. He could have just turned around and shot him more, or he could have shot him while he's fighting him. But he didn't do that. The only time the gun went off was after Mr. Granger came at him and tried to take the gun away from him. And based on that, that's not first-degree murder, Your Honor. I would submit that's manslaughter, but at the very worst, second degree. But there was no premeditation. There's no when Mr. Carter pulled the gun up, he could have shot then if that's what his intent was. If that was the premeditation. But the gun didn't go off until they started fighting. And that shows a lack of premeditation right there. And then the fact that Mr. Carter did not continue to shoot or shoot again while he was having Mr. Granger on top of him, fighting him. Despite what was testified to that Mr. Carter was on top of Mr. Granger, that's not what happened. It was Mr. Granger on top of him. He could have just as easily shot him again if it was his intent to shoot him in the first place. But that's not what happened. It only happened after they fought. I'm sorry. Thank you.
Okay. I appreciate you, Mr. Wallace. More than your client is a complete idiot in that this man took a kid from his mother on Mother's Day, but looking at his girl. I mean, how stupid can you be? And as angry as I am with the defendant, court must follow the law, at least as I see it. The charge here is first-degree murder premeditated. The defendant checks this young man, Mr. Granger, about looking at his girl. Mr. Granger steps towards him. First of all, he didn't understand what he was talking about. And it wasn't until the defendant pulls out a gun that Mr. Granger tries to push the gun away or take the gun from him. In the midst of that, this shooting happens. In this court's mind, that's not first-degree murder premeditated. That's second-degree murder. It's certainly not manslaughter. Nice try, but no manslaughter. But we do have a second-degree murder here. I don't think the people have established premeditated murder in that this was sort of a heat of the moment thing, not for manslaughter purposes, but for second-degree murder purposes. And that there was an intent to kill, because whenever you point an armed loaded weapon at a person and you fire a shot, there's an intent to kill. Or at least a question of fact as to whether or not there's an intent to kill. At the bare minimum, or an intent to do great bodily harm, or knowing the consequences of your actions could create death or great bodily harm. That's what we have here. We have second-degree murder. The court is satisfied that people have met their burden of probable cause as relates to the reduced count of second-degree murder in count 1, the felony firearm, prohibited person, possession by prohibited person. Count 3, felony firearm. Count 4, felony firearm. All third offense notices. Court finding those charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed criminal violence within the Wayne County Third Circuit Court Criminal Division of Proceedings. His arraignment on the information, date, and time will be, this is going to be the 21st. I'm sorry, 20. June 20th was the 19th. It's Juneteenth. June 20th at 9:00 a.m. And remanded to the custody of the Wayne County Sheriff.
I apologize, Your Honor. Wouldn't it be the 18th? Next Tuesday?
I thought it has to be, oh, today is, oh, today is Tuesday. That's the 18th. Thank you, Mr. Chair. June 18th, 2024 at 9:00 a.m. Defendant will be remanded to the custody of the Wayne County Sheriff. Purpose way.
Take care, Judge.
Thank you as well. You know, I have your exhibits. Judge.
Just this one.
It's 317, right? So we get 317 second.
Yes, Judge, thank you. Well, have a good rest of your day.
Thank you. You as well.
I've never seen something so we got it for my life. I've never seen it before.
Definition of a coward there.
Yeah. Mm-hmm.
Definition of the power there. Man, I'm gonna look at my girl.
What's the matter with these kids?
And then he tried to jump on him, and then he get the best of him. And so I've never seen nothing that stupid before. Never. Looking at my girl. That's not even okay.
Yeah, families on both sides. Ms. Hadar is supposed to be the prosecutor, so I haven't seen her yet.
What, did it turn into a homicide? I'm still arguing.
Yeah, I don't know.
Hadar's going to be the AP on the next case.
Yeah, that's well, that's who they got. That's who they got information from, Hadar. Yeah, I mean, to me, if somebody look at my wife, that's a compliment to me. Oh, my wife don't respond, I'm good.
I mean, that's a compliment.
You're right.
You know?
I'm good.
That's.
I mean, I know some guys can be disrespectful, walk up to you. I've seen walk up and talk to a girl and know she with another guy. That could be disrespectful, but just for looking, come on.
Die over looking.
And then he pulls out a gun instead of fighting. I mean, if you felt that way, why you gotta pull out a gun?
Slow fellow still get the best of it too.
Oh. What is this?
James Thompson in here too.
Yeah.
Tell you, man.
This chair.
Well, I could see she went over that. Well, he won't be having no woman. Well, he won't be having his woman anyway now.
Nope. Move on to the next guy.
I haven't seen witnesses. The family of the deceased, the family of the victim, and family of the defendant.
2016.
That was I didn't look at it.
2016. That's the best card.
He was in prison. Yeah, I heard Mr. Coleman got here, right? He said he had to talk to him. He needed to talk to him.
Yeah.
Prosecutor here, some two.
Okay. Did he get here yet?
No. What is it?
Yeah.
It's in the office or somewhere. I don't know where. There's a recall, that's why I was doing that.
Oh, okay.
Hey, so you can see the purpose of it.
How you doing? Still a short person?
Yeah.
Good morning, Your Honor.
Morning, how you doing?
Good, how are you?
Good.
Good. On Mr. Stewart, I was wondering, would the court permit me to talk to Mr. Stewart for another maybe like 10 minutes up here before we start the exam?
I'm sorry, say that again?
Would the court permit me to talk to Mr. Stewart for maybe another 10 minutes up here before we start the 11:30 exam? The reason I ask is because Mr. Stewart was unfortunately not transported. They took him away to MDOC on June 3rd.
Stewart there?
Yes, sir.
You can talk to him now.
Thanks, I appreciate it. Thank you, sir. Hey, all right, good.
Yeah, Coleman. Oh.
Yeah, so the unrelated robbery that they charged, they never charged. Yeah, so I still trying to figure out what that's. So I reached out to their goal. So remember when I talked here, they didn't get it every time. They got on the property.
So how much time does this guy will get? When he goes over?
He'll get a lot of years because he has an extensive record. He has the carjacking in his past, carrying concealed weapon, something else.
A lot of felonies.
He'll get some time.
What's the guidelines on that for him? What's the sentencing guidelines for him? For something like him, what's the sentencing guidelines? 30 or 40 years?
Probably a little more.
So it's pretty much a life sentence.
Because his criminal record is going to put him in a whole different career. He has a violent criminal record. He has guns. He's charged with an habitual third felony firearm. So that's a mandatory, what's it? Mandatory 10 years on top of whatever he gets.
So I have a question about the first degree premeditated. It can only go towards the shooting because, there was testimony that he stumped him, he choked him.
Yeah, but even that, if he had intended to kill him, why not put another bullet in him? You still had the gun.
Or why fight off rip, starting off fighting, why not just come in and shoot?
Right.
That's the.
Yeah, I don't think there was a true premeditated intent to kill. Not until the guy tried to get the gun from him. And he tried to get the guy off of him. Similar to a fight, somebody pulls the gun out, shoots the person, that's not premeditated. Although you may have thought about getting the gun and firing somebody, it's still not premeditated.
Even though you're the one that initiated everything?
Yeah.
It's still not premeditation?
It's just because you pull a gun off doesn't mean you're actually gonna shoot.
Right. And I don't think he would have shot him had the guy not tried to get the gun from him. He was just trying to punk him in front of his girl.
Now his girl gonna be with somebody else?
Yes, I am, man.
It's always 90%, 95% of the time. That's what's always over, man. That's why I'm getting a divorce right now.
Are you really?
I'm about to.
Yeah, that's easy.
I'm about to. I don't need them problems.
You consider the day off.
Oh, okay. I don't know if you checked in or not.
You're gonna be starting all over.
So, you came out right on the
Now,
So.
Now, if you just have one grade, we say that's what had long. But also. But I don't know way taller. The baby that's described, everyone else said, yeah, well, black. That's. Stay working. Black male, 5'9". Slight black. Other time, black male, 5. Like red. So, yeah. Yeah, probably some guy. Are you talking about I'm trying to see if that was connected. I know Brady was there. I don't know whether that was because I have. Yeah, did you say, hey, why are your prints on this bar? I don't know anything about it. Or sorry, investigating. So here's the thing: they say they're investigating, right? So they're not saying I'm investigating an armed robbery. Right? They're saying specifically that they're talking about it. Yes. I'm aware of it. I don't know. 5, 6. How do you know what grade? Later, they hanging out. Yeah, we classic. No, she could be a house, but not some of that stuff they be wearing. All these showing on that, it be look like 2 pieces of material. With that. Playing that. You can play. I like the group. Sometimes they come out some couples too, but it's still here. So I think that something. If it was, and I don't say it one right. It's just a double pay. They have to. No. They don't like to have. She's actually got a job.
I'll copy it. They just be long.
You don't do a separate.
Oh, that's where you are now. I don't know what's going on. That's staying.
It's supposed to be separate. It was actually about a year.
It's a PM talking about something. We put on the thing on the text at times, and then they will slow it. Yeah, if it ain't slow, it's great. Speaking of young children. Hi. You have young people. I don't need it. Just mosey it along.
Yes. So actually, I will.
Yeah.
Both of y'all lose a weight, like y'all some slim goodies over here. You know what about this one? What you mean? She's over here. You know me? So. You come on in bed.
Yeah, he's talking to his client now. Stop it. It's an old Amazon. Judge ready for you.
Yeah, okay, thank you.
Come on up, yep. Sit next to your attorney, stand up when the judge calls you.
Barn door.
Sorry. Oh, yeah, sorry, man. During the 11th page, they said we not only had officer seated on his table, but those were the two reports.
Oh, I'm sorry.
Yeah, it did.
Are we ready on Joshua?
Yes, Judge, I can actually just ask, I just got a new police report. Could I have just maybe like 2 minutes to read this very quickly? Thank you, Your Honor.
Whenever you say.
Yeah. So it's got a description. Yeah, I don't think that's much. Thank you, Judge. I appreciate that.
Calling case 1657956, people of the state of Michigan versus Joshua Lamar James Stewart. Defendant is charged in count 1 armed robbery, count 2 armed robbery, count 3 assault with intent to do great bodily harm, less than murder or by strangulation, count 4 armed robbery, count 5 receiving and concealing stolen property, $1,000 or more but less than $20,000, count 6 felony firearm. Appearances for the record.
Good morning, Rhonda Hadar for the people, P84161.
And good morning, Your Honor. Neighborhood Defender Service by Jonathan Coleman, P86151, appearing on behalf of Mr. Joshua Stewart, who is in custody. He stands to my left.
Tell us your name for the record, sir.
Joshua Stewart.
There's a date and time set for preliminary examination. Are you ready to proceed?
Yes, Judge.
How many witnesses?
2.
You have any preliminary matters before you call your witness?
Yes, Judge. So this is a case that came back from Michigan Supreme Court and then ultimately on a motion to quash was sent back to this court. I know at the time of the PCC, there may have been a little bit of confusion on my end as to whether or not we were doing a fully new exam or supplementing the original exam record. At this time, the people are seeking to supplement the original exam record, and I have a copy of that exam transcript here with the exhibits. At issue, however, something that we're going to, the interrogation in this case was suppressed by the Michigan Supreme Court. There is mention of that in here. The people and defense, I think, are joining in asking the court to disregard any testimony and about the interrogation and to not review the interrogation. I don't even have the interrogation in the binder created for you with the relevant, with the exhibits, all 3, 4, there were 4 originally, 3 exhibits now in the exam transcript. And then in addition to this, we have 2 witnesses to supplement the testimony that was already presented at the first preliminary examination back in 2016.
Mr. Cohen, you have any objections to supplementing the record with the prior testimony, sworn testimony, absent the alleged statement that was supposedly made by the defendant?
Your Honor, I don't have an objection to this particular procedural avenue in terms of supplementing the record with additional evidence. My review of case law seems to indicate that that is essentially one of the procedurally correct ways that the people can try and overcome the lack of sufficient evidence for a probable cause bind over when.
I guess what I'm asking is, we're not going to hold the entire exam all over again.
No, so I think that's not the intention. What I will say with respect to what evidence the court considers from the first preliminary examination, I agree that the entire testimony of one detective, Lucy, I believe it was, that pertained to Mr. Stewart's confession, which has now been suppressed, should be excluded from the court's consideration.
Absolutely.
Similarly, I would ask the court to strike as irrelevant and unduly prejudicial under Rule 403 reference to fatalities or decedents, or to the extent that any of these exhibits involve the medical examiner report with respect to Mr. Foster from the first alleged armed robbery and shooting. Because
you're not going to introduce the medical examiner report. He's not charged with the homicide.
Judge, it's already been introduced. It could be stricken from the record. He's not charged with the homicide. It is a part of the set of facts.
So that wouldn't be relevant.
Right, and specifically because Mr. Stewart was acquitted actually of those charges at a jury trial.
Okay.
I think, yeah, I think that's all, Your Honor.
Okay, may I approach with the binder?
Yes. So apparently I heard this back in 2016. I don't remember this case at all whatsoever. Nothing about it. I don't remember the defendant. I don't remember if it was a co-defendant. I don't remember who that is. I don't remember anything about the facts. So I am going to have an opportunity to be over this. But I will take the people's supplemental witnesses. And after I have an opportunity to read over this, I'll be ready for my bind over decision.
Yes, Judge.
And would the court want to wait to hear argument on the bind over until after the court's had an opportunity to review everything?
Yes.
Very good. Thank you, Your Honor.
Okay, so then at this time, the people are going to call Kyle Upshaw, who testified previously in the first exam, to supplement his testimony.
Okay. Okay.
Oh, okay.
And I don't think just.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Those aren't sunglasses, are they? Please remove them. It's not sunny in here. Please have a seat in the witness box next to me. Yes. Speak nice and loud into that microphone. Maybe give me ready.
Thank you, Judge. Good morning. Will you please state your name for the record? And Mr. Upshaw, were you at a house on Meade Street on May 6th of 2016?
Yes.
Is that in the city of Detroit and County of Wayne? Was that in the city of Detroit and County of Wayne? And what were you doing at that house on that day?
Just got work. I was cleaning my car.
Okay, and do you recall around what time of day you were cleaning your car out?
Around about 6 p.m.
Okay, and where was your car when you were cleaning it out? Okay, was it in the driveway or was it on the street?
On the street.
All right, and did something happen while you were cleaning your car out?
Yeah.
Okay, what happened?
Schools were up on me. Around me from
Okay, and you said some dudes pulled up on you? Okay, and how did they pull up on you? Did they walk or were they in a car? Say that one more time?
Going up first.
Okay, how did you see them when they pulled up?
Took a glance and looked, seeing the car.
Where were you when you saw them?
I was in the back seat.
You were in the backseat of your car? Okay, and how many people did you see when you turned around? You saw 3? Okay, and did you see a car with them?
Say you see a car?
Yeah.
Yeah.
Okay, what kind of car did you see?
Blue truck.
And did you
What was
see?
that, a blue what?
Blue truck.
Intrepid.
And did you see them exit that car or did you see them outside of that car?
Same outside.
Okay. And did you see any other people inside of that car? Okay. And what, if anything, did these 3 people do when you turned around and looked at them?
When I turned around, I had guns on my face.
How many guns did you see?
2.
Did they say anything to you?
Give me your money.
I'm going to object to the day and ask that this be clarified that they were speaking.
Okay. Thank you. Do you see anybody in the courtroom today that pointed a gun at you at the time, as of May 2016?
No.
Okay. What, if anything, okay, What, if anything, happened after these people approached you?
After they approached it, it ended up being a shootout.
Okay. Do you recall who shot first? Okay. Did you shoot back?
Yes,
And was anybody there with you that was shooting?
my brother,
What's your brother's name?
Danny,
Daniel what?
Claxton.
That's Claxton.
Yes,
And did you yourself shoot?
yes,
Okay. And did your brother shoot?
yes,
Okay. And were the people that came up to your house, were they shooting?
yes.
And how many of them did you see shooting?
2 dudes,
Okay. And what was the third person doing?
standing on the ground.
Okay. And what, were you injured as a result of this?
No.
Okay, was your brother injured as a result of this?
Yes.
Where was your brother shot?
Stomach.
Okay. And what happened after your brother was shot?
He was bleeding out bad. I ended up taking him to the receiving hospital, stuck with the car and drove to the hospital.
Okay, and what, if anything, did you see the group of 3 people do after the shooting?
Pretty much trying to get back in their car, I guess do the same thing.
Okay.
I'm gonna object and move to strike based on speculation.
Okay, do you,
Suspend.
that's fine. Without telling you what you think they were doing, did you see them do anything?
Clear it up.
Did they get back in the car?
Yeah.
Okay, and what car did they get inside of?
We'll try to.
Okay. Now, you indicated that you took your brother to receiving,
Yes.
and what, if anything, did you see when you got to receiving hospital?
So I took him to the Children's Hospital, and they rode through the tunnel. The detectives, they took me to receive. I was in front of the emergency on entry and exit. So, I was sitting there talking to the detective. I seen the drivers sitting in front of the truck,
Okay, and what car did you see the driver sitting in front of?
the blue truck.
And was that the same blue Intrepid that you had seen at your house? And was the person that you saw sitting on that blue Intrepid, was that someone that you had seen at your house that day?
Yes.
Did you know this person? Okay, and did you see it, why you're calling him the driver? Why are you calling him the driver?
Because he was a driver.
Okay, did you see the driver here today in court?
Yes.
Can you point and identify a piece of his clothing? Okay, can you identify a piece of clothing he's wearing?
Right now?
Yeah.
Green jump, green jacket, white t-shirt.
Okay, may the record reflect the witness has identified the defendant, Joshua Stewart.
So noted.
And did you see the driver's face at your house?
Yes.
Did you see the driver's face at the hospital?
Yes.
Do you recall what the driver was wearing at your house?
A t-shirt.
Okay, and do you recall what the driver was wearing when you saw him at the hospital?
Same thing.
Okay. And when you say same thing, do you mean the white
White
t-shirt?
t-shirt.
Okay. Did the driver ever speak to you at your house?
No.
Okay, did he ever speak to you at all? Now, how soon after your brother was shot did you end up at receiving hospital, if you recall?
Like 5 minutes, 4 minutes, 5 minutes.
Now, did you ever see the person you identified as the driver? Did you see him driving the vehicle that day?
No.
And did the person you see as that you've identified as the driver, did he ever point a weapon at you or have a gun?
No.
And do you recall testifying in this case previously?
Yes.
Okay, and fair to say this happened about 8 years ago? Okay. Nothing further.
Cross-exam.
Thank you, Your Honor. Mr. Upshaw, you've testified 2 times prior to today on this case, is that right?
I was one, yeah.
Well, you recall testifying at a preliminary examination, actually with Judge King here, in 2016, shortly after May. You remember testifying at an exam?
Yes.
Right, and you remember testifying at a jury trial in front of 12 or 14 people at Frank Murphy? Now, would you agree that your memory of these events from May 6th of 2016 was fresher in your mind back in May of 2016 than it is today?
Yes.
You recall testifying at the preliminary examination that you actually never saw this car pull up, this blue Dodge Intrepid. You remember saying that?
No.
Okay. You remember actually testifying that you heard what drew your attention? Was it you heard the screeching of tires or the burning of rubber? Do you remember testifying to that?
Yes.
All right. And that you didn't actually see these people get out of the car, right? So, no, you didn't see them, or no, you did see them?
No, I seen you get out, walking towards me.
Okay, so now you're saying you saw them physically open the doors and get out of the car?
So I walked across the street.
Okay, so that's different. Did you actually see them physically get out of the car, or when you first, go ahead.
No.
Okay, so when you first looked, you see a blue Dodge Intrepid, right?
Yes.
It's parked across the street, right?
Yes.
And you see 3 people, you said, outside of the car, correct? And 2 of them were walking towards you with guns.
Yes.
Do you recall testifying at the preliminary examination that the person who you said was in the driver's seat of that Dodge, of that Intrepid, never got out of the car?
I don't know.
You remember testifying at the trial that the person who you identified as the driver never got out of the car? I can just have a quick moment here, I'm sorry. So drawing the court's attention to page 47 of the preliminary examination transcript, line 9. Mr. Upshaw, you recall being asked the question, now did you see anybody else in the car, the blue car? Do you recall being asked the question, now did you see anybody else in the car, the blue car? Remember being asked about that at the preliminary examination?
Yes.
And you answered yes, followed by who else did you see? Remember that line of questioning? And you answered, quote, I guess the dude, the driver, remember that? That's a yes? All right, and then the question, you saw the driver, anyone else, right? You answered, and that was it. Okay, you remember that, right? Okay, thank you. And then later on in the exam, on page 51, you were asked the question, could you tell if there was anybody else in the car in addition to those 2 people that had the guns drawn on you? Remember that question?
Yes.
And you answered, quote, it was one more person still sitting in the driver's seat, right? All right, so at the preliminary exam, would you agree, you never actually mentioned the driver got out of the car. Would you agree with that statement?
I won't agree with it, but yeah, it was 8 years ago, 7 years ago.
Okay, so maybe it's better to say you don't recall whether you ever said the driver got out of the car. So then turning your attention to when you testified at trial in this case, which would have been, oh, I think later on, probably in the same year, November of 2016, thank you. And I know the court doesn't have benefit of this transcript, but it would be page 52. Do you recall Mr. Upshaw being asked the question, quote, and so the alleged driver in that vehicle, he never gets out of the vehicle, does he? Do you recall being asked that question?
No.
And you answered no. You remember being asked the question, you never walked up to the vehicle to look inside to determine what the individual had on. You remember being asked questions about when you were being questioned about what the driver, what you said the driver was wearing at trial? You don't remember that? But if I told you there's a transcript indicating those were the questions asked, would you have any reason to dispute that or disagree with me? And you testified again at trial that you never walked up to the vehicle to see inside what the driver was wearing, correct? And that's true, right? You never walked up to that vehicle, right? Now, but you're saying today that the driver actually got out of the car.
He got out of the car, picked the jewels up off the floor, put them in the car and took them to the hospital.
Okay, so let's be clear then. When you, is it true that what first drew your attention as you're cleaning your car is the sound of like screeching tires?
I heard screech sounds. I caught nothing of it. I turned around, seen two dudes running with guns.
Okay, so to be clear, when you first look after the screeching sound, you just see two people, right? Okay, because it's real important to be clear. You're saying three people. We want to make sure we're clear when you see them. At first, you just see the two guys with guns coming towards you, right? All right, and this third person's not outside the car, right? All right. Now, when you testified at the preliminary examination, there were, I guess, lawyers on both sides, right? Prosecutor and defense attorneys, right? You recall there were actually two defendants at that time, two people that were charged in connection with your case?
That's three.
Okay, would you recall there being two actual defendants in the courtroom?
No.
You don't recall? Okay. Do you remember being asked to identify a Deontay White as a person who had come at you with an AK-47 and shot your brother? Right. Yeah, you don't see Mr. White in the courtroom today, right? You remember Mr. Stewart?
Yes.
Right here, sitting in that courtroom at that preliminary examination? Right. You never once said or testified, that's the driver right there, did you?
Yes.
You did, at the preliminary examination. I can leave it to the court has the transcript to determine whether that's true or not. So your recollection is that you identified Mr. Stewart at the preliminary examination. Now at the trial, you were also asked whether you saw the driver in the courtroom, right? Or I'm sorry, I shouldn't say also. I'll say it for the first time, actually. You were asked, did you see the driver in the courtroom, right? And at that time, at the trial in November of 2016, you said, I do, I see the driver, right? And that's when you pointed to Mr. Stewart and you said, that's who was driving the car, right? And when we say driving the car, we're talking about outside of your house at 2086 Meade on May 6, 2016. Now, you recall being cross-examined by an attorney, Larry Polk, as part of that trial, questioned by a defense attorney.
Yes.
And part of that questioning, trying to clear up whether you actually saw Mr. Stewart outside of this house on 2086 Meade. Would you agree with that?
Yes.
All right. And you testified at that trial that you never saw Mr. Stewart driving the vehicle outside of 2086 Meade. Is that correct?
Yeah.
That's incorrect. All right. So you were asked by Mr. Polk, quote, because you never identified or saw Mr. Stewart driving that vehicle, did you? You were asked that, right? You don't remember? Okay. And your answer though was, I didn't see him driving it, correct? I'm gonna ask counsel for the people to stipulate the trial transcript. Mr. Upshaw did in fact, that question was asked verbatim, and that was his response verbatim, pages 48 and 49 of the trial transcript.
I'll stipulate to that, lines 25 through 2.
Court receives that stipulation.
Thank you.
Is that the transcript that I have here?
No, Judge, that's the trial transcript.
It is not. We certainly can submit that as an exhibit or email it to the court if that would be helpful. Mr. Upshaw, at the trial, you also testified that you did not see Mr. Stewart at the scene at 2086 Mead where the shootout happened, correct? Yeah. That's not correct, all right? So you recall being asked, page 55, line 21, but you didn't see him at the scene, question mark. Do you remember being asked that question? You remember giving the answer, no, I didn't see him at the scene. You recall testifying to that? Again, I would ask people to stipulate page 55 of the trial transcript of Mr. Kyle Upshaw, lines 21 through 22, that question and answer was asked and the answer was given.
So stipulated.
And I guess further, Mr. Upshaw, you were also asked, then you couldn't identify the person that allegedly was driving at the scene, and you answered no. Do you recall that? And I'd ask that, again, for stipulation that lines 23 through 25, that question was asked and answer was given.
So stipulated.
Thank you. Finally, Mr. Upshaw, at the trial, as you're being questioned about whether you had actually seen Mr. Stewart outside of 2086 Mead, as opposed to seeing him later in Detroit receiving, you were asked, quote, then you're just really making an assumption that that was the driver because you saw him allegedly later on at the receiving hospital, correct? You remember being asked that question? And you gave the answer 4 minutes later, yes. You remember that? Yeah. Okay. And again, I would ask that people stipulate it's page 56, lines 4 through 7, that question was asked and that answer was.
Yeah, it's lines 3 through 7, yes.
I'm sorry, yes, thank you.
See?
Thank you. Now you at some point you gave a statement to law enforcement officers from the Detroit Police Department about what happened on May 6th, correct? That's a yes?
Yes.
Sorry, our court reporter can only take down yeses and nos. An officer was writing down what you were saying, right? Yeah. And you were given an opportunity to review that statement, right?
Yes.
And to read it over, make sure it was correct and everything, right? Yes. And then you were asked to sign at the bottom of that statement, right? Yes. Now, when you were asked to describe the driver or the person who you said was in that blue Intrepid outside your house on Mead on May 6th, correct? And your response was, in response to the question, can you describe them all? Yes, the driver had a white t-shirt on. That's all I know of him. You remember telling police that? All right, and you signed off on that statement indicating that was correct, right? So when you're questioned by police on May 6th, this is when the statement was taken, right? At nighttime? All right, on May 6th, a little bit before 10 o'clock, the only thing you could say about that driver was a white t-shirt, correct?
Yes.
And this was just a regular, plain white t-shirt, right? No brand names, markings, nothing out of the ordinary, right? And now you're saying you saw Mr. Stewart near this Dodge Intrepid at Detroit Receiving, right? Okay, and you recognize that as you believe to be the same vehicle that was outside your address on Meade.
Yes.
And you see Mr. Stewart there, you say wearing a white t-shirt.
Yes.
Now, Mr. Upshaw, isn't that the reason that you are saying Mr. Stewart was driving that Intrepid outside of your address on Meade? Because you saw him later on the hood of that blue Intrepid. Isn't that true?
No.
Now, when you're driving your brother to Children's Hospital, right, it normally would be about a 10, 12-minute drive, is that right?
No, because I stay up to 75, so it's really like 5 minutes.
So it's fast to get to Children's Hospital, right? All right, now, they took him in and you didn't immediately go over to Detroit Receiving, right?
I went, it took me right, then I walked out of the tunnel and walked outside.
So you went over to Detroit Receiving fairly quickly?
Yes.
You didn't see the blue Dodge Intrepid right away, though, did you?
Yes.
You said you saw it right away. Now, when these two people, going back to me, these two people come out or come towards you with guns, right? I mean, you're immediately focused on those two people, right? Because one of them's got like a smaller sort of assault rifle.
Yes.
And one of them's got a handgun.
Yes.
All right, and they came up right close to you in that vehicle, right?
Yes.
And I think at one point you had testified that you had those guns in your eyeball, right?
Yes.
I mean, that's how close they were to you, right?
Pretty close.
Yeah, with pretty big guns in your face, right? Fair to say your attention at that point, as they walk up to you in your vehicle is on those two people, right? You're not looking at that car, right?
Yes, I was looking at the car.
So you're looking at both the guns and the car.
So, yes.
Pretty soon after these two people walk up to you, you hear a gunshot, right?
No.
Okay, well, you hear a gunshot at some point when they're out there with guns pointed at you, right?
Yeah.
All right, and then a shootout happens, right? That's fair to say a pretty stressful situation, right?
Sure.
You didn't know if you got hit.
Objective, this went to the form of questioning. Defense is getting pretty close to testifying. The defendant ask the questions to the witness.
What's your legal objection?
Form of the question.
What's wrong with the form of the question?
He's stating facts and asking the witness to agree or disagree instead of just asking questions.
So leading questions and process.
I understand.
So, again, very stressful situation for you, right?
Yes.
Your adrenaline's going at that point, right? You didn't know at first whether you'd been shot, right?
Yes.
And so you check yourself to see you're not hit, right?
Yes.
And then you have your gun at that point, right?
Yeah.
And you pop up and start firing back at these two people who are now shooting toward your brother at the house, right?
Yes.
Your attention's on them, fair to say?
Yeah.
And you're focused on those two guys with those guns who are shooting, right? And you're trying to shoot back at them, right?
Yeah.
Now, after some time, you empty your approximately 9-round magazine of your firearm, right? That's a yes?
Yes.
All right, and you hear your brother say he's hit, right?
Yeah.
And so at that point now, fair to say, you're now concerned about your brother, right?
Yes.
You actually run towards the side of the house, away from the street where this shootout happened, correct?
Yes.
And this would have been the left side of your house or the right side of the house?
Left side.
Which would have been farther away from this Intrepid parked across the street, right?
4, 5 feet.
Well, I'm saying you're running away from where that car is parked, right?
Yeah.
All right, and you're going to the side of the house where
I can take cover.
you hope to be safe from gunfire at that point, right? All right. And at some point, the shooting dies down, right? And again, your attention at this point is to go check on your brother, right? So you run up to the porch, right?
Yes.
And then you don't see your brother there. So you run inside, right? All right. At this point, there's no more gunfire at this point, right? So again, you're trying to get up to check on your brother at this point, right? Yeah. You're not worried about, you're not paying attention to people behind you getting in a car after this is done, right?
Yes, I am.
You are worried about them. All right, you're paying attention to them. Okay, but you're also running into your house at this point, right? All right. So what, maybe you spare a glance behind you to make sure they're not a problem anymore? A lot of glances?
Yes.
Now you're saying at this point, this is when you see who you say Mr. Stewart gets out of the car?
I go outside, I go upstairs to get my brother, I drag him down the steps. As soon as I'm about to stick him in the car, the other two victims was laying in the middle of the street. The steward ended up driving the dude, stick him in the car. I took my brother to the seat and he is right behind.
So you're saying they actually.
Dudes I was laying on the floor, they couldn't get up to get their own stuff in the car and drive their own stuff to the hospital.
So you're saying they hadn't left by the time you get down and get your brother in the car?
Then I left first, right behind.
And what you're telling us today about this, about the car still being there and these guys getting loaded into the car as you're still getting your brother loaded in, this is the first time you've ever testified to this, true?
No.
Not true. You mentioned this at the preliminary exam? You mentioned this at the trial? Right, you told this to the police?
Yes.
You didn't mention anything about this in your written statement though, when you talked to officers May 6th at 9:50 p.m., did you? Do you want to look at your statement? Would that help refresh your memory? You would agree, you never mentioned anything. You didn't give this level of detail or anything like this to the police as far as your written statement that you reviewed and signed off on May 6th. Would you agree with that?
I didn't hear you, sir.
I don't recall.
So again, can I ask, would reviewing your statement refresh your memory as to whether you mentioned any of those details? So looking at that statement, it's not going to help you remember what you told the police?
That's the answer.
Thank you. Now, at the trial, you said that the driver of this Intrepid outside of Meade was wearing not just a white t-shirt, but some black or dark jeans. You remember testifying to that?
Yes.
But again, you remember testifying at the trial that the only reason you knew anything about what this supposed driver was wearing on their bottom half is because you saw that person at Detroit Receiving, correct?
Yes.
So again, not because you saw this person and what they were wearing outside of the car at Meade. Right? The reason you know what you say Mr. Stewart's wearing, white t-shirt and dark or black jeans, is because you saw him wearing that outside of Detroit Receiving Hospital. So you're saying it's because you saw him outside of Meade?
I see him outside the house, yeah.
I can just have a quick second. Mr. Upshaw, you talked to a lot of police on May 6th outside of Detroit Receiving, right?
Yes.
Okay, both the detectives and just regular uniformed police officers?
Detectives.
All right. Now, you never told any of those detectives, hey, that's the guy right there, the driver outside my house, did you? You never pointed at Mr. Stewart?
Yes.
So you're saying you told officers, that's the guy, that's the driver?
Yes.
Do you remember which officer you talked to?
No.
It was a male, female?
It was a male.
Black, white, Hispanic?
Mitchell.
It was Officer in Charge Mitchell? And that's who you told on May 6th. You pointed at Mr. Stewart or told him the guy sitting by that Intrepid, that's the driver from me?
I was talking to three, I don't remember, I was talking to three officers. So, I
But,
don't know if it was Mitchell, I don't know if it was the black lady, I don't know if it was other people. So,
but it's your testimony that you told officers on May sixth, that guy out there by that Intrepid, that's the driver at that shooting and armed robbery outside me.
yeah.
I think that's all fine. Thank you very much.
Can you redirect?
Yes, Judge, just briefly. Mr. Upshaw, fair to say you testified at least 2 other times in this case prior, right? And do you recall every single question that every single lawyer asked you in this case when you testified? And now was the, earlier you testified that you saw Mr. Stewart outside of the Mead Street house?
Yes.
And was the only time that you saw him outside of that house when he got out of the car to help the people that shot at you, your brother?
Yeah.
Okay. And then when was the next time that you saw him?
Steve Hospital, emergency room.
Okay. And, nothing further.
Okay, Mr. Upshaw, let me make sure I understand you correctly. On this particular day on Mead Street, you are at your car and you're cleaning your car out, right? And you hear a car, you hear tires screeching, someone pulling up. But you didn't pay very much attention to it at that time, right?
I took a short glance.
Took a short glance. And at some point in time, you see 2 guys running towards you with weapons drawn. Is that right?
Yeah.
Okay. And when that happened, you started shooting.
No,
They started shooting first.
it must have been my brother shooting first, because he seen the whole thing, not the person.
So your brother started shooting. And then they started shooting as well.
Yeah, before I shoot him.
And I take it 1 or more of these guys were shot.
Yeah.
All right. At the time that you see the 2 people running towards you with guns, you didn't see anybody else at that time. Is that right?
No.
Okay. But you take off running, but you look back because you're concerned about your brother. Is that right?
I ain't take off running yet. When he started shooting, I was right on the other side of the car. I returned fire.
Okay. At some point in time, you take cover though, right?
Yes.
And then when you take cover, you look back and you see the 2 guys that were running towards you lying in the street. Is that right? And then another person comes and picks those 2 guys up and put them in his car. That's this blue Intrepid, right? And that person you say is the defendant we have here in court, right? You got a good look at him at that time?
Yes.
And then you saw him again at the hospital driving that same blue Intrepid. Is that right?
Yes.
Any questions based on my question?
Nothing for the people.
Just very briefly, Your Honor, Mr. Upshaw, if you saw, was only one of the 2 guys that came out with guns shot? If you saw. Yeah, I'll phrase it another way. Do you know whether both of the guys you say were lying in the street, whether both of them were shot or just one?
I think both were shot.
So I guess you don't know for sure. Is that fair to say?
I don't know for sure.
All right. That's all I think.
All right. Thank you, sir. You may step down.
Okay, we're, at this time, Judge, we're gonna stipulate for the admission of People's Exhibit, I'm gonna mark this People's Exhibit 5. Kyle Upshaw's transcript from the trial. And then with that, the next witness is, I'm sorry.
So stipulated.
Yes, Your Honor. Thank you.
Court receives that stipulation and will admit it. That's going to be People's Exhibit what?
5.
Okay.
At this
Exhibit 5
time,
is admitted.
thank you. The people call Police Officer John Sietra. Permission to approach.
Yes. Raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. Please have a seat. May begin when you're ready.
Thank you. Will you please state your name for the record?
John Seaton.
And are you employed?
I am by the City of Detroit Police Department.
And were you employed how long have you been employed in that capacity?
11 years.
Were you working on May 6th of 2016?
I was.
And did you have the opportunity to respond to the area of Savage and Packard Street?
I did.
That's in the city of Detroit, County of Wayne.
It is
What were you responding to there?
a shooting that just happened.
Did you respond by yourself or do you have a partner?
No, I had a partner, Eric Pengelly.
Can you spell his last name?
Pengelly.
And do you recall around what time of day did you respond?
Approximately around 7 o'clock.
And what, if anything, did you see when you made it to these scenes?
Upon our arrival, I observed a black male that was suffering from a pair of gunshot wounds. There was another male doing chest compressions on him.
And were you able to identify the male that was wounded?
Yeah, he was later identified as Aaron Foster.
Okay, and the male that was doing the chest compressions, were you ever able to identify that person?
I'm not sure, but he was with a friend. His friend was Ito Walker.
Okay, and what, if anything, did you or your partner do when you saw the Mr. Foster injured?
We determined, we asked zone dispatch for an ETA from medics to the scene. They couldn't give a firm estimate of time on how long it was going to take. So at that point, based on his condition, we decided to load him up into our scout car to convey him to the hospital.
When you say we, who are you referring to?
Eric Pengelly, my partner.
Okay, and which hospital did you take Mr. Foster?
We took him to Detroit Receiving Hospital. I drove with my partner to chest compressions all the way to the hospital.
Okay, and while you were at that hospital on May 6, 2016, did you encounter any other gunshot wound victims?
Yeah, we just wrapped up.
Sorry, can you just say what you did not need?
Okay, I just wrapped up getting semi-cleaned up from our car and myself. I was notified by security that there was a vehicle.
No, object, just to hear say, that's what other
Not
people
all
told
for
him.
the truth of the matter, so why he took whatever action to affect him in this. I'll take it for that limited purpose.
Thank you.
Okay, what, if anything, did you learn when after you got cleaned up at the hospital?
That there was a vehicle outside and there was another person suffering from gunshot wounds.
And did you identify who that other person was?
Yeah, he gave the name Duran Prophet, but his name was Deontay White. I recognized him from working in the 11th precinct.
Okay, and do you know, was there anybody else with Mr. White at the hospital?
Yes, there was the driver of the vehicle.
And
I'm gonna object to that conclusion of driver based on also speculation, lack of
Get some
foundation.
okay,
Sustain.
did you did you speak to anybody else at the hospital that was there with Mr. White?
Yeah, Mr. Stewart.
Okay, do you see Mr. Stewart here today?
I do. He's sitting next to the defense counsel in a green jumpsuit with a white shirt underneath it.
May the record reflect the witnesses identify the defendant Joshua Stewart?
So noted.
And did you speak to Mr. Stewart at the hospital that night?
I did.
Okay, where was Mr. Stewart when you spoke to him?
He was outside the vehicle.
Okay, what kind of vehicle?
It was a blue Dodge Intrepid. The rear window was busted out and it had bullet holes down the passenger side of the vehicle.
Okay, and where in relation to the vehicle was Mr. Stewart standing?
I think he was standing in the rear if I recall.
Okay. And did you speak to anybody else at the hospital that was related to Mr. White?
Related to Mr. White, no.
Okay. And what, if anything, did Mr. Stewart tell you?
I'm gonna object this time. Foundation, voluntariness, I'd like an opportunity to voir dire this witness if
Okay.
possible.
Can I lay a foundation? Did you, you indicated you spoke to Mr. Stewart?
Yes.
Okay. Now, did you ultimately end up detaining Mr. Stewart?
After it was some other sequence of events happened, yes, he was taken into custody for being in possession of a stolen vehicle.
Okay. Now, the first time you spoke to him, was he in custody?
He was not.
I'm gonna object, Your Honor, that calls for a legal conclusion.
Did you,
He said he didn't put him under arrest, but he's not in custody. How is that a legal conclusion?
Well, the question of custody triggers whether or not Miranda warnings need to be given.
You'll have an opportunity to cross it down.
Thank you, Your Honor.
why were you speaking to Mr. Stewart at the time that you saw him at the hospital?
To determine where they were at when Mr. White was shot, so I could locate a scene. I could put that over his own dispatch, so I could ask him to go look for that scene.
At that point in time, was Mr. Stewart a suspect to you at all?
No,
Okay. Did you have any knowledge about Mr. Stewart being involved in a crime at all?
I did not.
Okay. And so when you were speaking to Mr. Stewart, did you give him any kind of Miranda warning?
I did not. He just told me that he was walking the area.
I mean, just yes or no, did you give him a Miranda warning?
I did not.
Okay. And why not?
Because he wasn't a person of interest at that point.
Okay.
I suspected him of any crime.
Did you take him anywhere else when you questioned him for that first time?
No.
Okay. Was he still standing next to that vehicle?
Yeah, I asked him if he could sit on the trunk, because there was a lot going on.
Okay. And is that typical for you to do for witnesses of crimes?
Yes.
Okay. Why do you ask witnesses to stay where they're?
I mean, so I can figure out what's truly going on. Like I said, it was pretty chaotic. My radio was going off. There was another shooting coming out. Like I said, it was just a lot going on at the moment and a lot to process. I didn't want to have him walk away and not be able to ask me questions that I might have, forgot to ask him.
Okay. So now, what, if anything, did Mr. Stewart say to you?
I'm no object, Your Honor, and I'd like to, my objection is voluntariness. I'd like to point here that
Voluntariness doesn't come into play if he's not in custody, if he's not being interrogated.
well, I would like to ask questions of voir dire this witness with respect to whether the court can come to a legal conclusion that he was in fact in custody for purposes of Miranda, to flesh out the issue of whether he's detained, whether his freedom of movement is in any way, shape, or form meaningfully curtailed, which is what the case law indicates. It does not require a formal arrest. Both Miranda and Michigan case law
Already indicated that he was not the target or subject of any criminal investigation. He's at this point merely a potential witness, not a defendant.
But he's been detained. He's been ordered to sit down and not leave, which I am arguing is a formal detention that does require the reading of Miranda warnings. I have case law if the court would like. I mean, this issue has sort of been briefed and put on pause in the circuit court with respect to whether these statements were voluntary or whether they were the result of custodial interrogation.
Okay, board there, based on what I've heard, officer, there was not a custodial interrogation.
I appreciate it. Thank you, Judge. Officer CJ, you get word that there's another gunshot wound victim while you're in the hospital, right?
Correct.
And you come outside to see this blue Dodge Intrepid already out there?
Yes.
All right, and you see Mr. Stewart, he's standing by the rear of that vehicle.
Correct.
All right. You see this vehicle is riddled with bullet holes and busted out glass, right?
Correct.
And again, based on what you've been told, there's a gunshot wound victim of some sort.
Correct. They've got a gurney next to the car and they're pulling the guy in the passenger seat.
Right, now at that point, fair to say, I mean, you are assuming there's been a shooting, right?
Fair to say.
And probably an unlawful shooting, right?
I mean, I don't have any details of what's happening. I mean, all I see is, I wasn't dispatched, I have no background information. All I get is word from security, hey, there's a car shot up and there's a guy shot in the passenger seat.
Is it fair to say that at that point you assumed there might have been a crime that had been committed, however?
Someone shot, because that's a crime. That's a pretty fair assumption.
Okay, so you didn't assume that anything bad had happened or that there had been a crime committed?
The shooting is what I assume, because that's what I could see in front of me.
But as a law enforcement officer, I mean, you're only investigating things that you think are crimes, correct?
Yeah.
So I mean, there's no need to be asking questions of people unless you think a crime's been committed, right?
Well, we need to find a scene and know where it happened at, right?
Again, to determine whether a crime has been committed, right?
Sure.
Okay. So you say that witnesses, it's your common practice to tell witnesses to stay put, sit down, or not leave? Is that correct?
I asked him if he would have a seat on the car so I could figure out what was going on.
Okay, you didn't tell him.
I never said that he wasn't free to leave, that he was under arrest, that he couldn't go anywhere. I asked him if he would mind sitting on the trunk of the car, and that's where he sat. I told him that he couldn't leave it out.
So you're saying you didn't order him to sit on the car?
I asked him if he would sit on the car.
And he complied with that request?
Sat on the trunk of the car.
You're fully uniformed, correct?
Yes.
Armed?
Yes.
Okay. You're the only officer out there at that time?
My partner is behind me at the scout car, and I think there's security around me.
So maybe multiple armed and uniformed officers out there at that point?
Security officers.
Okay. Sure. And DPD, at least you and your partner, right?
Correct.
With a marked scout car out there? Yeah. All right. And all right, so you did not tell Mr. Stewart that he was free to leave, correct?
I didn't tell him he wasn't either.
Okay, so was the answer to my question, yes, that's correct? You never told him, hey, Mr. Stewart, you're free to leave?
No.
And you never told him that he was not being detained?
I don't remember exactly what it was exactly, so this is 8 years ago, so.
I understand. You never told him that he was not under arrest?
I didn't tell him he wasn't under arrest either.
But again, my question was, you didn't tell him he was not under arrest, right?
No, they didn't place him in handcuffs either.
Until later.
Yes.
Now, you had your partner keep Mr. Stewart on that car at that scene, and you left him to go talk to someone else. Is that right?
I had him stand by with them. Yes.
All right. Again, now, Mr. Stewart, Mr. Stewart was not free to leave when you started questioning him about what happened with this shot up vehicle, correct?
It was the initial, when I walked up to the car and I asked them what happened, where they were at. And then after that, I never asked them any more questions.
Well, before you asked him questions, you had him sit down, right?
No, he was standing next to the vehicle when I asked him the initial questions.
Oh, so now these questions happened before you had him sit down? That's what you're telling us?
And that's what I stated earlier too.
All right. So
I just asked him questions and I asked him if he could have a sit down in the back of the car.
After his responses?
Correct.
Just have a quick second. That's what I have for Miranda. Thank you, Judge. I appreciate it.
What if anything did Mr. Stewart tell you when you spoke to him for the first time at the hospital?
That he was walking down the street and saw Mr. White shot and got in the car and drove him to the hospital.
Do you recall if he told you where this happened?
They were in the area of State Fair and Cruise.
Okay. And do you recall what he was wearing at the time you encountered him?
T-shirt and blue jeans.
Do you know what color the t-shirt was?
I don't.
Okay. Sorry if I asked already, do you recall what kind of vehicle he was with?
He was with a blue Dodge Intrepid that had a busted out rear window, gunshot, bullet holes in the passenger side.
Okay, nothing further.
Cross-examine.
Officer Seajet, you authored a report in connection with your interaction with Mr. Stewart at Detroit Receiving Hospital, is that right?
Yeah, so
Right, and back in 2016, did you have body camera?
we did not.
Right, and you had received, I'm sure, extensive training on the importance of police reports and their purpose, is that fair to say?
Yes.
Right, and again, especially in an era where you don't have any body cam reporting your interactions with civilians, your police reports were even more important arguably than they are now, is that fair to say?
Sure.
In terms of, very important to put relevant details in those reports.
Yeah, I was a relatively new officer too, so.
But still, even so,
Yeah.
you knew that it was very important to document in as detailed a fashion as you could your interactions and relevant investigations to criminal investigation, right?
Sure.
All right. And in your report, and this kind of, I'm circling back a little bit to this issue of Miranda, but you wrote in this report In the front passenger seat was a victim with multiple apparent gunshot wounds to his upper torso. The passenger of that vehicle identified himself as Drawn Prophet. I secured the vehicle and the driver, one Lamar James Stewart. You remember, you stated that in your report, correct?
Correct.
Right. And then after that, at least chronologically in your report, is when you start stating, again, in this report, that's when Mr. Stewart says he's walking down the street somewhere on the east side and saw this guy shot in the vehicle, jumped in the car and drove into the DRH, right?
I don't know, I have my report in front of me, so I can't.
We're taking a quick look at it, refresh your recollection as to, at least chronologically, if that's how it was stated. You secured the driver and then you asked him questions. Would it refresh your memory?
I'll take a look at it.
And refresh your memory.
Still talking for me here, so.
Understood. If it doesn't refresh your memory, just tell us. Thank you. Is your memory refreshed? So fair to say that at least as you wrote your report, the order that you wrote the report in is that you secured who you referred to as the driver, Mr. Stewart, and then Mr. Stewart stated these things about, is that about being involved with the vehicle?
Yeah, but I don't know if it's chronologically right when it was recorded.
So good point. So fair to say you don't actually remember 8 years on whether Mr. Stewart said these things before you sat him on the car or after you sat him on the car?
No, I walked in, they took him out of the gurney, I walked over and said, where were you guys at? What happened?
All right. Mr. Stewart, you're saying at Detroit Receiving, you recall he's wearing a t-shirt and blue jeans.
Correct.
Now, 8 years ago, in November of 2016, you remember testifying at a trial about this case, right?
Yes.
And you were asked questions about what Mr. Stewart was wearing at Detroit Receiving, correct?
Yeah, blue jeans and t-shirt. I can't remember the color of that either.
Okay, well, you testified then that he was wearing blue jeans, right? And, sorry, that's a yes?
Yes.
And that he was wearing a shirt, correct? You didn't specify it was a t-shirt?
It's a t-shirt.
You didn't specify that at the trial, correct?
No.
And you didn't. Taking a look at Mr. Stewart's booking photo, refresh your memory as to the color of his shirt that he was wearing at DRH on May 6th of 2016.
Sure.
We just have a moment. Your Honor, may I approach?
Yes.
All right, Officer CJ, I'm going to hand you this document here and let us know if your memory is refreshed when it's refreshed.
It's refreshed.
All right, so what color was Mr. Stewart's top that he was wearing at Detroit Receiving Hospital?
I don't know. That's the shirt that he's wearing in his book.
Was Mr. Stewart, he was arrested by you?
He was.
Did you transport him to, would it have been Detroit Detention Center at the time?
It would have been.
All right, and he wasn't transported with any extra clothing or property, right?
I don't recall.
So would reviewing, let me see, are you familiar with the Sergeant Gunspiller, Andrew Gunspiller?
Yes.
Do you recall whether he was out at the hospital, at Detroit Receiving Hospital on May 6, 2016?
I don't.
You recall whether he authored a crime scene or conducted a crime scene investigation. Report.
I don't.
So again, just to be clear, at this point, you don't recall whether what color Mr. Stewart's top was, is that fair to say?
I don't.
To be clear, now you never saw Mr. Stewart inside of this Dodge Intrepid.
I did not.
Did you have interaction with or talk to Kyle Upshaw? Kyle Upshaw being the alleged victim of an armed robbery at 2086 Meade shortly before your interaction with folks at Detroit Receiving.
I did not.
I can just have. All right, thanks, Officer Seated. I think that's all I have.
Can you redirect?
No, nothing.
Also, if you have any reason to believe that Mr. Stewart had committed a crime at the time that you asked those initial questions?
I did not. They were purely investigating to figure out where they were at, if there was anybody else there.
You indicated in your police report that the defendant, Mr. Stewart, as well as the person that was shot was secure. Is that right? Okay. Was the person that was shot, were they under arrest?
Well, and Judge, I guess I would just object. His testimony was actually that his report reflected he secured the vehicle and the driver. There was never any testimony about securing the gunshot wound victim.
Maybe I misheard that. Did you come across the person that was shot?
I did.
Where was he when you saw him?
He was sitting in the passenger seat of the vehicle. He was being taken up by medical staff at the range.
Okay.
And taken into the triage room.
Did you have an occasion to speak to him?
I did.
Again, was he under arrest at the time that you spoke to him?
He was not.
Did you have any reason to believe that he had committed a crime?
I did not.
Any questions based on my questions?
Not from the defense. Thank you, Judge.
Thank you.
Nothing further as far as testimony goes for the people at this point.
Does the defense have any witnesses?
We don't have anything to supplement the record at this time, Your Honor.
I'm sorry?
We do not have anything to supplement the record with at this time, Your Honor.
All right.
Thank you.
So now I have a little homework here, thanks to you guys. So I will read this. It doesn't appear to be too long. By Thursday?
Very nice schedule, Judge. Yes, Thursday the 13th, isn't it? I can do that.
Thursday, 13th at 10 o'clock.
Is it possible to do later in the morning?
Had a preliminary examination at 11. And it looks like I also have some.
I will do everything I can to make 10 o'clock.
Since all we're doing is arguments that's combined over in my decision, so we can do 10:30.
Okay.
Is that good?
That was, yeah.
We'll do 10:30.
Thank you, Jeff.
Legislation.
And the court has the trial transcript testimony of Mr. Upshaw as well, correct?
I guess that's what all the stuff I have here, right?
Well, so one of that is the preliminary exam, and I think you will introduce, the transcript of Mr. Upshaw's testimony. Yeah, thank you.
Fine.
Yes.
Okay. Yes, I have.
Thank you, Your Honor.
I need time to hold on to this.
Okay. We do.
Did you need to
Just,
anything first?
please.
Okay.
Yeah.
And we're down to 1:30.
No, it's fine.
Okay, so young ladies in the courtroom, would you mind interns?
Hopefully, but we don't know yet.
Yeah, we don't.
You don't know yet. What you mean?
We haven't gotten assigned or.
But you are interns with the court, you just don't know where.
Yes.
Oh, okay, all right. Well, welcome, I'm Judge King, very pleased to meet you.
You as well.
Have I spoke to you guys before?
No.
Yeah, I was here, on a field trip. A man.
Oh, domestic violence.
I recall you from, roadway.
Oh, yeah.
Yes, yeah.
So this court is a little different. I'm one of 4 preliminary examinations. But I do especially on this kind of case. Domestic violence, sexual conduct cases, other child cases. Other cases, but so those are those. So most cases that are charged get most of the time. So this is a bit of an unusual case. I had this case way back in 2016. I think this case back in 2016. Murder actually took place in 2016. Actually, yes. Yeah, So turn this thing, because he was in custody. That's the anti-terror. So just because the rest doesn't mean that you have to do it, right? That's what makes sense. It's not so easy. You're not questioning. Just because the rest of it, right? But he's saying that even though he wasn't formally arrested, he was strained to sell the car. Police officer, I got you. I'm holding the gun. You don't feel the question. Hi. And it's not.
I'm not saying like, oh, stickers.
I'm assuming I'm the tape.
You never know it.
That the same thing I did. Some guy went to another.
You want them there.
It's unusual. Because I'll take some. Last time, 2006. Make sure you come back to testify to 2016. It's telling you to read the record. So I heard it today and make the decision. If I dismiss it.
Okay. Even when it's, even when the decision got.
It takes a while. Actual problems. Right. You have to decide two they go in, they shoot some just all three. Even though you didn't.
I didn't know.
Okay, I enjoyed it.
How are you?
I just had to deal with a pit bull instead of the service animal. Okay, whatever. I can't even. Bring it on. I was too tired. I did, come on, I said, I got this security, I walk her to the counter, let her pay me to get her out of here. I was,
Yes. First get that in 2016.
They were just eager to sit in one of their cases as normal. So years old.
You heard that one.
Few years old. I told them.
I'll let you.
The next one is 208.
What that is?
One of them is number 17-year-old staff.
That was on the news too.
What was it?
I think that was on the news.
She said, I see.
Trust me, she's gonna. She's like. They don't judge. They don't. I mean, they're old. I mean, that's not really old, but that like.
Could you like take them somewhere else or start
You think we got to play baseball? That's not how this works.
Wait, so what's the difference?
Invite me to your favorite spot. He does that, he does that. That get him.
And then you get back on the phone. Get the whole story for you.
Yeah, every time. When they say that and I'm in here, I love the cake. When you get bring it to, I just look down like, oh, you didn't say that.
Right. Shaking You don't want to tell me that's the question.
You'll be back there.
Thursday. 10:30. No, it was 10. 10? Oh.
Yeah, but he gets.
Oh.
And that's the sad thing, when I was a clerk, they had to refer the name to her, I was like, oh, we have to go out there. And they still not there. That's all we said.
That's exactly.
So you go and eat, you know, you have to.
Thank you for talking to us.
No
And
problem.
answer my question.
No, we back. We'll bring it back.
A lot like somebody
Do you know how somebody
maybe I'm terrible.
Debson? Debson?
Oh, Debson. Oh, I've spoken to Debson a few times.
My dad is like new paradigm for education. You probably know me.
She's a daddy girl. He wanted to come to the internship.
Okay. I said, no, Dad, you can't do that. I got her. I got her. She's a big girl.
No, I am the only girl, and I'm the youngest, so.
No, I'm not, but I'm not that bad. I think
It's
wasn't
not
trying to
me,
follow
it's
me.
him. I don't know what it is.
I was like, man.
I didn't know what she did.
Sorry, Daddy, stay.
Thank you, Judge.
Thank you.
Yeah, Daddy, what's that?
That evidentiary hearing, is that by Zoom? The Doric and Duncan sign.
Oh, I thought it would be in person.
In person.
Court is in recess till 1:30.
did you set it for 8:30?
Yes.
They're not gonna have it today.
Oh, yeah, that's right. What day did I set that for, Friday?
20.
Friday, 20.
That's a
Oh,
Thursday.
Thursday. So I punched it.
Set it for the afternoon, or something down here.
Oh, yeah. Let's set it for the, right after that. That works. something to eat, ladies?
Oh, I did.
Okay.
I snack up here.
Get something to eat, ladies?
Get my cookies.
there? Hey. Huh? It was here. Oh, medical. Yeah. Oh, so it's just. Some chips or something for you, kiddo. Maybe get some more chips. Good.
Mr. Coleman.
No, I can't be retired. Yeah. Yeah.
You got no room. What's your name? What's your name?
Stand up. What's your name? Tessa Coleman.
Okay. Braids, trying to show off.
Oh, man. You just, no, you want her in?
No.
You have a seat.
come crispy every time.
Looking like a picture in the barber shop for the hair salon. Playing, man, look at you.
Every time. Hey, how you doing?
I'm happy, doing good.
But to get in trouble rocking them bad boys.
Don't hurt yourself, nothing.
Get in trouble. You walking around with them like that.
Man. Everybody asking, who keep doing your hair? And everybody my stylist now. Every time you get your hair done, oh my God.
Shoot a video around here.
I'm shooting a video.
Shoot a video. Oh, 48 on the hallway. Yeah, I saw him talking. Y'all let me know.
You need your copies or no?
No, I'm good. As long as I go in the book, turn it in the Bible.
Right.
I'm gonna do what I've seen in my life.
What do you do?
Any card. Got somebody looking at his girl.
Really?
Yeah.
For looking at his girlfriend.
For looking in the liquor store.
And killed him? Oh my God. World's dumbest criminals, huh?
I just hate that download. Because you can't get
Kathy, you probably be back to get her. I gotta go back to the front door.
All right, I'll see you in a minute. Send me mom.
Right, all right.
lunch.
They'll be with you shortly, okay? They'll be with you shortly.
Okay, later.
Or do you want to?
Yeah.
Either one's good for me. Yeah, okay, which one do you want? I gotta eat something. So.
Hey.
No problem. Smart.
That's what she told me. She told me that too, that she hates this sticker now. She's like, yeah, that's my y'all. Yeah, that's true. Yeah. I told her.
What they get? 72.
And I said, she said that. I said, wow.
251, how old are they?
Thank you. I asked her, what happened?
I'm close, birthday 73.
73.
Well, she'll be 73, September 72. Okay. They mentioned that. Yep, September 4th.
So you want to, although, why don't you want to get her?
I don't.
About to find out.
Me too.
Yeah.
So there's one,
1:30.
what's that you open? So I get that to work, that's what
This is just gonna be today, then we still sweet.
Are we looking tomorrow?
No, you ran tomorrow, right? Very good.
That's nice. Yeah.
Oh, James.
Small, still there, never had problems.
Come back at 3:30.
I know.
Gotta get be there. I called around. 700.
Talking about that last one. First, you got charged with homicide. Jail since 2016. Jail is one on jail. So they dropped the charges on her. Now, this, listen to that. Took them out on that offense. Even though you know, most of the body was fired, they was crazy. But to say they got to saw somebody injured, don't get out. You don't get it.
Like, that wasn't stated, bro.
That's what he said. And that's what the evidence showed, was when the last trial we heard. The brother, he said the same thing he said today, 2016.
Yeah.
That's so on the coach.
Nobody here yet?
I haven't seen the prosecutor, but I've seen everybody else.
Okay. Hey, how you doing today? All right. You thought our 10 o'clock was bad. Wait till you hear this one.
Oh.
10 o'clock. I don't know.
It's like the first one at 10 o'clock.
What's up, young lady?
Oh, yeah, how are you?
If I had to get smart.
Karen Dan, DANNE. Yes, ma'am, 78733. Judge, I'm just gonna get my computer hooked up here.
Okay,
I gotta get connected to Zoom.
I'm just trying to pull out some words. Take your time.
Oh.
Your first name, Stanford S-A-N, S-A-N, or Stanford, without.
I'll make sure I got the right one.
Thank you.
That one case with blind victim and the diversion issue. Nina. Yeah, Egerton. She got diversion, I guess you guys are trying to come up with some money.
Yeah.
This was in other cases.
I didn't remember
Mia. I don't know.
Mia. Was it last name?
Yeah, she did? Oh, it's he, okay. Okay.
So he put over to the one first.
And you're gonna go for that?
We're doing some.
Okay.
He's gonna be the Zoom reserve.
And you're gonna just get.
Yes. We'll go.
Okay.
Mia only.
Well, when I don't.
This is my five, I just went about 4,620. Never remember this.
Have a witness list? No, there will be no witnesses.
No witness.
None.
Well, there's an exhibit.
We're gonna stipulate to some facts and play the interview. And Hardy and Shell. If that's okay?
Sure.
There was one officer up here and I just released him. Very straightforward.
Are we ready?
We're ready.
The only thing is just I want to be able to connect to Zoom so that I'm not fumbling on the record.
Stand next to the attorney.
That's there's nothing wrong with the 36 district court.
Yeah,
website.
it's working.
It's working now?
Just try, yeah, just.
There was no issue on my.
Do we have a name report?
Yes. I'll have 3 exhibits. And the medical record is Lee. And then I'll spell the last name for you. H.
What?
H is in hat. L is in Larry. A is in apple. V is in Victor. A is in apple. T is in Tom. Y is in yo-yo.
Letter. Yeah. Just super.
I've never met her. Is she new?
The 11, she's been around a long time.
Has she?
Yes.
The witness.
Back when I was in the prosecutor's office.
But I just don't do nothing.
Judge, do you ever remember a prosecutor who was a medical examiner? Back in the day?
Who was it?
He was Melody something. If you give me.
I don't remember that.
Yeah, she was a prosecutor and she.
Okay, that's the closest joint judge, we let them know you're here. For whatever reason, when I share my video, I can't turn off the sound of my computer. So unfortunately, it's gonna play on both the screen and my computer, Judge. I can, but if I do that, it mutes this as well. I have my.
think so, try it.
So I hit mute on the bottom right-hand corner of my computer.
Do you have another mute somewhere?
Put it in the computer and on the screen, is it causing problems? Is it echoes?
I see, look at this, Judge.
Ms. Coleman is hard of hearing. I'm not sure if that might help her hear it.
I'm sorry?
Ms. Coleman is very hard of hearing. I don't know if that's gonna help.
Yeah, I can play it on my computer and put the computer over there so she can hear it from there as well. Or I can bring my laptop up to you, Judge.
I mean, so long as I can hear it.
Okay. All right, when the people are ready to proceed, Judge.
You call it. Calling case 24-574-46, People State of Michigan versus Tessa Lynn Coleman. Defendant is charged in count 1 homicide, murder, second degree. Appearances for the record, please.
Good afternoon, Your Honor, to you and your staff, Aaron Dan for the people, 78733.
And good afternoon, Your Honor, Stanford Shulman, P43230, appearing on behalf of Tessa Lynn Coleman. Ms. Coleman, can you tell us your name?
Tessa Lynn Coleman.
Could you hear me?
Yes.
Okay. And are you having trouble hearing the judge and the prosecutor? If you let us know if you can't hear somebody, okay?
Okay.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Have any preliminary matters you'd like to begin with before we call this?
No, Your Honor.
How many witnesses do you have?
I actually have 0 witnesses, Your Honor, and I'll just put a couple of things on the records, if perhaps they are preliminary in nature.
Okay.
Judge, as the court is going to ultimately learn, this is an issue, this case is ultimately going to boil down to the issue of intent for preliminary examination purposes. So in the interest of time and judicial economy and all of that, defense and I have agreed to a number of things. First, the people would move for admission of people's proposed exhibit number 1, 2, and 3. 1 is the medical examiner report authored on May 31st, 2024. 2 is the constitutional right certificate of notification forms executed by the defendant, Ms. Coleman. And 3 is the interview dated May 27th, 2024 of the defendant, Ms. Keeson.
Do we have a stipulation as to all of those?
Well, we have a stipulation as to the first 2 for sure, the medical examiner's report and the findings. In lieu of the testimony of Dr. Valti, we would stipulate the report for purposes of, for purposes of the preliminary exam only. We would stipulate to the Miranda warnings or advice rights that was marked and admitted. The actual interview, Your Honor, I have no objections to the court hearing it, but our position is going to be part of our argument is that once she asked for a lawyer, the question should have been suspended. So I want you to, I would ask the court to make a decision as you hear that, whether the court will consider the balance of her statements. I know the case law in the court is quite familiar with it as well. I can make some argument, but I'm okay with the court hearing it and then proffering it, and then you could decide its admission or not, and then we can always argue for the weight, the credibility, and ultimately the intent.
Okay. We also have a stipulation as to the identity of the victim being Brenda Tanks.
Yes, Your Honor.
For that purpose.
So stipulated.
Court receives that stipulation.
And Judge, I think we'll stipulate some basic facts as well.
Yes, there was an officer that was present who came to court. We had no objections to waiving that witness. Again, it was a first responder, and we're not trying to shortchange anybody, but we don't think these are necessarily the facts that are critical of the court's decision. So I would stipulate to the police officer's report, and you can summarize it or present it in any fashion.
What's the victim's last name?
Tanksley, Tankley.
And I can either put in the responding officer's report or the investigator's report. Judge, I will offer to the court, for the purposes of preliminary examination only, the I'll just do the investigator's report, Judge. Maybe just stipulate some basic facts that on May 26th, 2024, Scout responded to 8538 Trust on City of Detroit County awaiting for a person's staff. Upon their arrival, they discovered Brenda Tansley suffering from a stab wound to the left side of her neck. She was transported to Sinai Grace Hospital, where she ultimately succumbed to her injuries. When the officers arrived, the defendant, Ms. Lisa Coleman, was on scene. And it was there that she stated something to the effect of, "I stabbed her." It's for the purposes of the preliminary examination only, I'd ask that you stipulate to those facts.
So let's take the purpose of the preliminary exam.
Okay.
And at this time, Judge, I would ask for leave to play the video.
No objection to publish that.
And it is, for the record, 16 minutes and 30 seconds in length.
And this is People's Exhibit
3.
And again, it's subject to the court's ruling on the admissibility of the statement.
Understood.
I started the video at 55 seconds, Judge.
Do you have any problems with reading or writing?
No.
Can you read 1 through 5 out loud for me?
I have a right to remain silent and that I do not have to answer any questions put to me or make any statements. Any statement I make or anything I say will be used against me in the court of law. I have the right to have an attorney present before and during the time I answer any questions or make any statement. If I cannot afford an attorney lawyer, one will be appointed to me without cost by the court prior to any questioning. I can decide at any time to exercise my rights and not answer any questions or make any statements.
Do you understand those? Do you understand your rights?
Yeah.
Can you initial on each line for me and then sign? The little line mark. Put your initials.
I'm going to need an attorney.
So you're choosing not to talk to us then?
No,
okay.
I'm going to talk to you, but I don't have any money for an attorney. That's what I'm saying.
Right, I got you.
Okay.
But you want to wait for your attorney then?
No, I want to tell my side of what happened from day one.
Okay, so only because you brought up attorney. If you want to talk to your attorney first, then we got to stop this conversation and you can talk to an attorney. Or you can choose to talk to us now. It's up to you.
I have nothing to hide, so I don't see any reason not to answer tell you what happened.
Okay.
Okay, number one, I've been living with this woman for 2 years.
What's this woman's name?
Brenda Tanksley.
Okay.
We're both Jehovah's Witnesses. We go to the same congregation and everything. And at first I didn't want to move in, and she kept begging me. She had lost her husband 3 years ago. My purpose of moving in with her is to help her get over her husband and to take on a fresh contact. Okay, at first everything was okay. Little by little, every 2 weeks, then she'll make a statement like, oh, you forgot to take the trash out. Like it's my personal job. I clean the bathroom every day. I never ask her to help or nothing. These are things I do myself. Anyway, she started nagging and complaining about little petty stuff. So I would go to my room and I had earphones and I plug it up and I just listen to calming music until either she leaves the house or do something else to get her mind off nagging me. Okay, I've done that for 6 months. Sometimes she'll go upstairs and relax, and when she comes down, she'll have a better attitude. But nevertheless, the nagging, the fussing, all that stuff, it's starting to add up. So we would go before the brothers. They had brothers to listen to your problems and try to find a compromise and a solution. Okay, she would agree while we were sitting there, but then she'd go back to the same old habits later. So I said, well, maybe if I take a long walk, why can't she see that this nagging and fussing, it doesn't work for adults?
Right.
So, what is it I'm doing that's aggravating you or keeping you in a bad mood? She would always say it was her medication or somebody down the street or whatever, but we never seem to resolve the problem. Anyway, this year she went up on the rent $50. You know, she was going over her budget and she was short, and she just said to me, I'm going up on your rent $50. Now, I thought that was unfair, and I wanted to go to the brothers at the hall, but then I said, they can't do anything about the rent increase. So I might as well just go on and pay it and hope that things will settle down. But they didn't. But I'm trying to think exactly what happened that day. The cause us to get into a verbal argument. But anyway, we get into an argument. She tells me, you need to get out. Of course, because I've been taking all this abuse for 2 years, then I got angry and I grabbed that knife and I says, I'm not going nowhere. And that's how we got into the scuffle. But yeah, she told me to leave. Where am I gonna go? I'm 72 years old.
Right.
My cousin came last week to bring their application for a senior citizen apartment. I paid out the application. She took it back to the place, and before I could get her answer, then I had that consultation with her. She gonna tell me to get out. And I don't have nowhere to go.
Right.
So that's how it started.
You said you had an altercation with her. Did you hit her with a knife or stab her with a knife?
Yes, I did.
You know how many times?
Huh?
How many times?
Once. And then we started scuffling in the kitchen. And she pleaded with me to put the knife down, and I did.
Okay. Did she have anything in her hands?
Like what?
Did she have a knife or any kind of weapons or anything?
No, she didn't.
Okay. What'd you do after?
I went to my phone and I called 911. She's sitting in the table telling me that she can't breathe and to get her some help. And I did. While I'm talking to the operator, she's giving me directions on how to get a towel and put some water on it and apply it to her chest with light pressure. Meanwhile, this is what we're doing. And I said, is the scout car on the way? She says, yes. Look out the door. I looked out the door, and the car was going the opposite way, and I said, tell him to turn around, and I did like this so he would know that was the house. Anyway, we came in, and they're asking me questions. The lady, the operator is telling me what to do, and I says, I'm talking to the police. So she says, I am the police. So I handed her the phone, and she said, no, I don't want to talk to her. Tell me what happened. How did she get injured? And I told him.
Okay. Do you have any questions? No. Do you have any questions?
Of course, I wish that I hadn't done that, but why did she tell me to get out? And she know I don't have nowhere to go.
I don't know.
Huh?
I don't know why she would tell you that. I don't know.
Do you remember where you hit her with the knife?
Do I remember hitting her with the knife?
Do you remember where on her body?
It was
And the next?
next.
Where'd you put the knife?
I took the knife, off where it says, put that knife down, and I put it on the table. And it was there when they arrived. The phone and the knife were on the table.
Okay. So this was like build up emotions and anger that led to this?
Yeah, and like I say, going up on the rent, you know, I'm a senior citizen. I only have a limited amount of money. And a person, they have no right to say, oh, well, I can't pay my bills, so I'm going up on your rent $50 without prior notice.
Okay. Do you have any questions of us?
I'm sorry it happened like that, but like I say, when she told me to get out, I lost it.
It's understandable. I understand. Okay. So what happens from here is I'm going to present everything to the prosecutor's office, and the prosecutor to decide what to do from here. Okay? So we should know something probably by today or tomorrow.
Okay, I gotta get the handcuffs back on.
Yeah, just so we walk it back.
I'm stopping the video at 15:35, Judge.
So, yes, well, argument or as okay, it's the disability. Yeah. So, court has heard the video and audio. The question is, did she unequivocally invoke her right to an attorney? And that is the law that I believe is the standard. You can rescind that once you start asking for an attorney. What's interesting about this now with this discussion is that the defendant inquires about a lawyer and she says, I can't afford a lawyer. But of course, one of the Miranda warnings is you can get a lawyer even if you can't afford one. Now, the officer didn't say anything to her about that, but our argument is that once she asked for an attorney, you know, he does follow up with questions. Do you still want to talk to me? But really, you're not supposed to ask any more questions. Once you ask for an attorney, it stops. It doesn't. I want an attorney. Well, you can still get one later. Those kind of things. That's once it's unequivocally established that you want an attorney, it stops. She does go. She continues on and says, "Well, I can't afford an attorney." I mean, does the officer have an obligation to say, "Listen, you will get one at the expense of the county. You won't have to pay for a lawyer." It is in the Miranda warning. She read it. She initialed it. That's our position that her statements were sufficient to yes, the mechanism of not inquiring any further to suspend the interrogation should have been once she said, I want an attorney. With those statements, there should have been no further interrogation.
Just very briefly. So the controlling case law in this is People v. Davis 191, Commission Act 25, case law from 1991. The Davis court ultimately said that while a defendant may assert his or her right to remain silent any time, the assertion must be unequivocal and the defendant must do so unambiguously. The Davis court specifically held that if the accused makes a statement concerning the right to counsel that is ambiguous or equivocal, or makes no statement, that police are not required to end the interview. In this situation, I do think that there's, when you're watching the interview, she says something to the effect of, I'm gonna need an attorney. And I think that Detective Colwell was really careful with I think he thought about it and was careful about his next question. I think he said something, so you're choosing not to talk to us? And she says immediately, I'm gonna talk to you, I just don't have any money for an attorney. And he says, do you want to wait for an attorney then? And she says, I want to tell my side of the story. And there was a little more exchange back and forth. I don't have the exact quotations, but one thing that I did note from watching the interview is that the defendant herself then begins talking herself. I don't think that the first answer that or the first statement she says about what actually happens is in response to a direct question. Even barring that, Judge, it was clear from the interview that the defendant in this case wanted the police to make sure that they knew that ultimately she was going to need an attorney because she didn't have money for one. And so therefore, Judge, I'd ask the court maybe to consider the statement admissions for the exam.
And in response, Your Honor, I think we agree on the law. Once she says, I want an attorney, you can't ask any questions. You can't say, well, hey, do you want to reconsider? Are you sure? It stops. It's a red line because.
Can you play that beginning for me?
Sure.
I hear it, but I don't see it.
I have to log into Zoom, Judge.
Okay.
Do you have any problems with reading or writing? Can you read 1 through 5 out loud for me?
I have a right to remain silent and that I do not have to answer any questions put to me or make any statements. Any statement I make or anything I say will be used against me in the court of law. I have the right to have an attorney present before and during the time I answer any questions or make any statement. If I cannot afford an attorney lawyer, one will be appointed to me without cost by the court prior to any questioning. I can decide at any time to exercise my rights and not answer any questions or make any statements.
Do you understand those? Do you understand your rights?
Yeah.
Can you initial on each line for me and then sign? The little line, put your initials.
I'm going to need an attorney.
And then sign. So you're choosing not to talk to us then?
No,
okay.
I'm going to talk to you, but I don't have any money for an attorney. That's what I'm saying.
Right, I got you.
Okay.
But you want to wait for your attorney then?
No, I want to tell my side of what happened from day one.
Okay, so only because you brought up attorney. If you want to talk to your attorney first, then we got to stop this conversation and you can talk to an attorney. Or you can choose to talk to us now, it's up to you.
I have nothing to hide, so I don't see any reason not to answer.
Okay, so the defendant unequivocally indicated that she's going to need an attorney. The officer, I think, is getting clarification from her as to what she was asking for. Because apparently she indicated that she wanted to talk. Now she's saying that I want an attorney. So he's getting clarification that you don't want to talk to us. And the defendant says that I can't afford an attorney. Officer then says, there's an interchange between both of them. He talks about, do you want to wait on your attorney? And he's been made full aware that the defendant has asked for an attorney. So he's proceeding cautiously before he asks her any questions. Ask her, does she want to wait on an attorney or do you want to talk to us? It's up to you. He gave her the opportunity to say if she wants to talk. Say you can wait on your attorney or you can talk to us. The defendant decided to talk. The statement appears to this court to be voluntary. And this bright line rule that you're talking about, Mr. Schuman, that once the defendant asserts their right to an attorney or asks for an attorney, that all questioning has to stop. I submit to you that any questioning about the case has to stop. He's getting clarification from her as to what it is that she's really asking. So that's my position. I find that the statement was knowingly and voluntarily given. Anything else?
I'm just trying to stop my share here.
I can do that.
Okay.
Right.
Thank you. I was really struggling there, panicking a little.
I thought you were down there just showing off.
No, I was panicking. I didn't want, because I know we're live. I don't think anything was on there that was of interest.
Okay.
Judge, I would also like to read into the record just a couple of things from the medical examiner report. Is Judge Dr. Labadie. She says, it's in my opinion that the death was caused by stab wound to the neck. She indicates there was a stab wound on the left upper neck. The wound tract passed through the neck soft tissue, left internal jugular vein, esophagus, and transverse process of the C3 vertebra. She indicates the manner of death is homicide. And she also indicates the date that she's pronounced dead is May 26th, 2024. At this time, Judge, I would move arguments for bind over or.
Your Honor, given the admissibility of the statement, when you look at that statement, it's the only real piece of evidence for intent. So we have the defendant who's 72 years old.
Yes.
Okay. And you know, this is based on her own words and even the words of the officer. Highly emotional. 2 years of this exchange between her and her roommate. There was a stabbing, which is one time, which I think is important. And even the officer characterizes it as highly emotional, and he actually uses that. It's a buildup of emotion. So, you know, she calls 911, she administers first aid. I think she's even flagging someone down. And those are really consistent with the heat of the moment. This is actually a textbook manslaughter. If you were to teach this, someone in the heat of the moment, there's a lot of emotion.
But you know, you do acknowledge that for manslaughter, there has to be some kind of adequate provocation.
Well, provocation. Okay, so the textbook one is come home and your girlfriend or boyfriend has someone else there.
Yeah, that's adequate
And you
provocation.
literally grab a knife and you stab the person.
Yeah, that's heat of the moment.
Heat of the
adequate
moment, right,
provocation.
right. So here is, you're getting kicked out of the apartment. It's very emotional. You gotta leave, you gotta live on the street. It's very emotional. And even you can see how she describes the event. Even the officer, it's not the same interrogation, who done it. She spills it all out on the camera about her emotion, about how it was a tussle. There was, and the nature of the weapon is a knife. I don't know if it was a kitchen knife, there was no specificity, but it didn't sound like I went downstairs and I got my knife, I went and got my gun. This was within a snap.
If she did that, she would probably be looking at first degree.
Right, maybe, right, yes, that's the degradation between first degree murder. Second degree murder is more of shooting something into a crowded area. You're mad and you're gonna come in, someone's gonna die. Someone is going to die tonight. I don't know who it is, but I'm mad. I'm gonna shoot up that house. I'm gonna shoot up that.
That's the depraved part. That's the third form of the intent.
Right.
So you have the intent to kill or intent to do great bodily harm, less than murder, or wanton and willful disregard
that likelihood
the likelihood of your actions to cause death of great bodily harm.
Right. So those are, I know you too often have to make that call between first degree, second degree murder, and even manslaughter. And so here's a situation that's just as emotional as you get. I mean, I know
here's the burning question. You could be absolutely correct that manslaughter fits better with these set of facts. However, that's not for me to decide. I'm here to decide if people have presented evidence on each and every element of this crime that they've chosen, which is second degree murder. They presented evidence on each and every element of this particular crime for this court to bind over on second degree murder.
Well, it still has to be proven by probable cause. Right? Obviously, and second, the court can make those. That is a hard call. The court is here to make that call. I mean, it's not simply everything is a question of fact. I mean, if I say it's nighttime right now, it's a question of fact because I said it. I guess the question is, you look at this and you say this should not be bound over on second degree murder. This should not be bound over on first degree. This is the heat of the moment. This is a woman who was acting in emotion. It is right out of the definition of what it means. I mean, what's the difference between voluntary and involuntary manslaughter? That's even more specific. It's a more fine line. But how do you decipher? How do you distinguish between second degree murder, first degree murder, second degree murder, and manslaughter? Manslaughter is this case. This is the emotion. This is the heat of the moment. This is grabbing the knife, not the gun. This is the one stab. This is the administering help, calling 911. It's a buildup. It's a overflow. It's almost an uncontrollable reaction to news. Girlfriend now is a boyfriend. In this case, you're going to be evicted. You're going to be sleeping on the street.
Judge, I can respond to specific inquiries from the court, but otherwise I do think this is a clear question of fact. The trier of fact, intent is obviously something that the jury is ultimately going to have to look at if we ask for bind over. Thank you. Judge, if I may add, I pulled up a quick case during argument. The Michigan Supreme Court in 1991, the Pouncey case, 437-36382, indicates provocation must be such to cause a reasonable person to lose control and act out of passion rather than reason. In general, insulting words are not adequate provocation. We're talking about raising a $50 worth of rent, and that is even if we take the defendant's words as vital.
So again, the people that have chosen to charge this defendant second degree murder, there are 3 levels of intent the court can consider. One is an intent to kill, I think a reasonable argument could be made that by taking a knife and stabbing someone in the neck with that knife is an intent to kill, or an intent to do great bodily harm, or creating a very high risk of death or great bodily harm by stabbing someone in the neck. That's not an issue, so far as this court sees that their intent element has been fulfilled. That the defendant caused the death of the 75-year-old woman, Brenda Tanksley. And as far as manslaughter goes, the provocation has to be, there not only has to be adequate provocation, but it has to be reasonable, or something that would cause a reasonable person to act in the manner in which they did. So even with the example that you gave, and I come home and I find my spouse in bed with another person, that could cause a reasonable person to act without time to cool down, to reflect on what was going on. I don't think that get out is the same thing. Get out of the house, even though me being put out of the house is going to render me homeless. It's not adequate provocation by a reasonable person to act in the manner in which this defendant does. But you could find a trier of fact too violent. It's possible. That's what makes it a question of fact to be determined by a trier. The court is satisfied that people met their burden of probable cause as it relates to the charges contained in the complaint. The court finds those charges were committed in the majority. The court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. Her arraignment on the information date and time will be June 18th, 2024, 9 o'clock.
With the court refer the issue of bond to the pretrial services, like, do they call it DSU anymore?
DSU or pretrial services.
The judge this morning has to go with DSU, please. I took the tender screen. Is that what it is? Defenders? Defendants.
Or department. Department screen.
All right, so if you could refer that, I appreciate it. The June 18th is the air.
We'll do that.
Okay. Next court date is June 18th.
Is there a notes on the table?
Thank you, Your Honor.
Is there notes on the table?
Just
Yeah.
You keep
Yeah.
this.
I'll let you know.
See, they'll come get you, okay?
I like keeping these.
Okay.
You need this to judgment.
Okay, okay.
Okay, that concludes the docket for today. I'll see you tomorrow, same bad station, same bad time.
Keep them now.
Transfer.
Cartoon, something, they don't even feel real. I know.
Paperwork, whatever. Got a second? You got a second? Let me hand this paperwork.
Okay.
2 minutes. See you tomorrow. See you tomorrow.
All right, see you tomorrow.
Take care, Judge.
All right, you too.
Got tomorrow.
See? You know.